Now live. Right, good morning, everyone. The court has reconvened for the hearing of Petrochemicals Limited and Sino International Limited, civil appeal number 13 of 2021. The appearance are as before.
Yes, my lords. Good morning. I would like to sit down as soon as possible to let my learned friend have a fair opportunity to respond. But can I try and address your lordship's outstanding queries to the extent I can? the first question, which I didn't answer very well yesterday, relating to the discrepancy between the 66% figure and the 45% figure. Just to explain that, the position is 45%. So the judge's paragraph 2 of his judgment is in error when it refers to 66%.
Is it 45 or 48.3%?
Let me just try and address the 66 point, and then I'll come back to you with the detail on that. I'll wait for my own friend, Mr. Williams, to double check the point. Where the error crept in, the reason the judge made the error, it's not something he completely made up. It actually was an error that was originally contained in Fame Dragon's skeleton at first instance. It was, however, clarified in oral submissions before the judge at first instance. So you're obviously welcome to look at it if you want, but in the transcript, which is in bundle F at tab 63, counsel on behalf of Fame Dragon at the hearing at first instance, Mr. Robinson, at page 270 to pages 273 of the transcript, he had clarified by reference to the evidence I showed you of Mr. Lai that the position was the 48.35% figure. So I apologize, my lord. It's the 48.35% figure. And essentially he corrected his skeleton orally. So had the judge had that in mind, or had he reviewed the transcript on that particular point, ideally his judgment of paragraph 2 would have referred to that 48% figure. Now it's not a completely random 66 figure, because there were financial statements from 2016 which had shown that Fame Dragon at that point in time had 66%. And it's also, it may be coincidence or it may be linked, doesn't really matter, but Mr. Zhang's evidence is that he is the beneficial owner of 18%. So between Mr. Zhang and between the Fame Dragon liquidators, you do get to roughly 66% on that side of the defense of the company. So in a sense, the board, the current board who stand for the company for the purpose of this appeal, they have at least the support of that 66%. And then the balance of the company's shareholders, subject to whatever's happened, is the public shareholders through the listing process.
Thank you. That's very helpful.
So hopefully that assists on that point, and I apologize again for not having done a better job yesterday. There's a small point that my own friend, Mr. White, has asked me to just clarify. It may be that he will make more of this in his submissions. But in terms of the reconstitution of the board, there is one director who is continuous from the before period to the current period. We say nothing turns on that fact. If anything, it's helpful to us because he was one of the non-executive directors at the time who has now essentially formed a different view as to the nature of the transactions that he was part of a board of that had approved. I think my own friend, Mr. White.
My lord, yes, it's Mr. Lai Fei Lawrence. He was a director from 2014 until at least 2020.
So I just wanted to make that point because Mr. White was anxious that I hadn't left you with a flavour that there was a complete change of every member of the board, but we say it was a very different board from the moment it was reconstituted over time with the introduction of the Mr. Zhang as the executive and Mr. Lai, for example, as the chairman. Coming back to the more challenging forensic questions that the Lordship has, which in a sense I've been asked to remind the court are illustrative of the difficulties of trying the dispute rather than accepting that it's a matter for the Hong Kong court in due course with the benefit of all the evidence. Would it help if I tried to do my best yet again to explain the matters by reference to Mr. Lai's evidence? But before I do that, can I just flag up one point which might be of significance chronologically and which perhaps was not fully clear to the court. Okay.
Echo. Smart, I think that's from Court Smart.
Okay. Can I ask you just to pick up volume C, tab 24, which was the first affirmation of Mr. Zhang. Sorry, C for Charlie. Yep. And start at tab 24 being the first affirmation of Mr. Zhang. And I just wanted you to turn to page 177, please. Paragraph 17. Well, it's 16 in a sense you have to look at, because at 16 you see that there's a reference to the fact that Titan's holders historically were Fame Dragon and Guangdong Zhenrong Energy, GZE. Fame Dragon being a Hong Kong company, GZE a PRC company. And at 17, what Mr. Zhang explained was that both Fame Dragon and GZE are currently in compulsory liquidation. In particular, winding up petition was presented against Fame Dragon on the 25th of October 2016, and Fame Dragon was ordered to be wound up by the Hong Kong court on the 3rd of April 2017. But then the next paragraph, he explains that after Fame Dragon was ordered to be wound up, Mr. Arab and Mr. Cohn of RSM were appointed as liquidators on the 6th of February 2018. And the reason I draw attention to that is because in the Hong Kong proceedings, and we can turn to the orders made if your lordships want to look at them in the D bundle, but it's similar to actually, in a way, the Bermuda position. When a company is ordered to be wound up, the immediate order of wind up simply appoints the official receiver's office in Hong Kong as the default liquidator.
Even if there are JPLs in place.
Even if, well, had there been JPLs in place, then I think they would continue in the interim, but they weren't in this case. I don't understand it. So in this case, on the 3rd of April 2017, Fame Dragon was ordered to be wound up. The official receiver steps in, but in a sense, nothing happens until sometime later on the 6th of February 2018, when the insolvency practitioners are appointed as liquidators.
So is the official receiver a provisional liquidator?
Yes, I don't think that's, I mean, it would be helpful perhaps just to look at the orders if I may trouble you to keep C available, because we'll come back to it, but just turn to D1. If you can pick up D1 tab 43, please turn to page 849. Page 849 and 850, what you'll see is the winding up order that was made by Mr. Justice Lamb on the 3rd of April 2017. And so on the page 850, the order is the company be wound up by the court under the provisions of the company's winding up rules, and the official receiver is constituted provisional liquidator of the affairs of the company. What you then see over the page at 852 is the order appointing the liquidators essentially as permanent liquidators. And at 852, the preamble shows that it was an application of the official receiver and provisional liquidator of Fame Dragon for consideration of the resolutions and determinations of the first meetings of creditors and contributories of the company. And then there are the reports are read. And at page 853, the order is made appointing Mr. Arab and Mr. Cohn as the liquidators. Now, the reason I mentioned that is because that April 2017 event, the winding up of Fame Dragon, does have chronological significance. It would be submitted in the Hong Kong proceedings and therefore here, because it explains why in April 2017, the then management of the company saw an opportunity to behave in a way which would result in the company eventually suffering the loss as a result of their actions. Because essentially there was a degree of a vacuum on the part of the shareholder, Fame Dragon, as well as GZE in its own liquidation proceedings in the PRC. So the majority shareholders essentially were somewhat decapitated for that period of time between 3rd of April 2017 and the appointment of the RSM liquidators in February 2018. And you can see from this evidence, and this affirmation carries on if you were to have read it or were to read it again, that not only was there the convertible bond issues and the fictitious transactions of which we have been discussing, but lots of other incidents of which complaint is made in terms of transfers of shares. So these paragraphs, for example, explain, you'll see that the subsequent paragraphs that we were just looking at C, at page 178, complains of the fact that there had been attempts to transfer Titan shares to various third parties, all of which, it is said, happened after the commencement of those winding up proceedings of Fame Dragon, and therefore would be post-petition dispositions or preferences or whatever you characterize them, and they're the subject of the clawback proceedings. So I mention all that because we now turn to the forensic questions about Mr. Lai's affirmation. And I just want to put it in context why it is that it's really April where opportunity to start committing the fraud relating to the convertible bond starts. And the commodities trading, there's also in the evidence an explanation that commodities trading had only just started in the second half of 2016, just the year before, because it was only then that the company had come out of its court-supervised provisional liquidation and scheme to enable it to start doing business. So it's not as if there was years of track records of commodities trading. There's just a few months before we get to April 2017. If I can then just now take you back to Mr. Lai's affirmation, because I need to have it open to try and address your lordship's questions as I had understood them. But
Tab 29.
we go back to tab 29, please. And in a sense, what I would hope might be helpful is if I can just start with the appendix document, which is at 329. And to the extent I can try and add my gloss to what is being represented in this appendix, but with the benefit of instructions, this section of the document, the appendix, is grouping together transactions by reference to the contracts that relate to each transaction. And they relate to the 2017 transactions, some of which are not necessarily part of the table that was at paragraph 51, because paragraph 51 covers payments over the period of time from April to December relating to, for example, transactions starting with 2017-0004. But at Appendix 1, you'll see that the first transaction referred to at the top of page 329 is 2017-001. And so 1, 2, and 3 are not the subject of the table 51. But just pausing there, and I apologize if this is playing catch-up with my Lord President Clark. The first one, which you'll see, the first contract within that group of transaction contracts is a 28th February 2017 contract, and the payment was made on the 1st of March.
Yes.
Now, that had a payment term of 1 working day.
Mm-hmm.
The related transactions to that had payment terms of 5 working days, and the return rate, still very small, but for a transaction that completed as between February and April, if you extrapolate, the analyzed return was 4%. Now, we don't accept that when this comes under full forensic investigation in Hong Kong, that this was a legitimate commodities trade. But at this point in time, there's not particular significance about that one because it completed, and it completed within 5 working days, and the payments were made promptly by the 18th of April.
Why do you say it was not legitimate?
Well, we say, I mean, in a sense, we're not in a position to accept that it was legitimate because of the events that follow. And because of the fact that the companies involved, on our evidence, are all closely related companies.
That doesn't make it illegitimate, does it?
Well, the reason we would say it is illegitimate is because it's a publicly listed company, the manner in which disclosures are given to the market and the way in which the company's auditors scrutinize transactions, for example, all depend on the company's commodities trades being at arm's length with independent third parties. Because otherwise, if there's self-dealing, they come under a different level of scrutiny, both at board level as well as auditor level and regulatory level. So what would be illegitimate would be to make it look like it's arm's length trading, if in fact it's not arm's length trading.
That still doesn't answer the question as to why you say it's not arm's length.
Sorry, the reason we say it's not arm's length is because as a result of our evidence based on the investigations, the companies involved in the trades were all owned or controlled by Mr. Wei Bing and Mr. Tang.
Yeah.
So if Mr. Wei Bing and Mr. Tang, representing Titan, are trading with a company which they own or control on the other side of the transaction, it's not an arm's length transaction.
Right. Yeah.
So, but for present purposes, and for purposes of the forensic analysis that's in the earlier paragraphs complaining of the flow of funds, these transactions are being identified as grouped transactions. And for present purposes, no particular complaint is made about that transaction, save that it lays the foundation for what follows.
Mm-hmm.
The same is true of the second transaction at page 329. Now, on this occasion, you'll see that the payments complete between March and May, and the payment terms are before 15th of March and before 28th of March. And that results in a return rate of 0.1%, annualized at 1.43%. So again, no particular complaint for present purposes, but again, the foundation was to follow. You then have, over the page at 330, a transaction that looks like actually it might be an independent arm's length transaction involving Wing King, Titan, and Rui Hongyi. Now that's one, because of the timing within which it completes and the terms upon which it completes as to payment, has a return rate of 0.1%, but annualized, actually a profitable transaction. So in a sense, of these three, that one has more characteristics of a more genuine commodities transaction.
At 658%.
At an annualized return of 658%. Now, one might say, well, that would be a preposterous profit to make if it was a long-term transaction. But because it's a short, it's a
modest profit over a very short period.
Exactly, modest profit over a short period. But the point is, because of the Mr. Lai's extrapolation for that, he would say, well, if you were a commodities trader, that would be a wonderful deal to have achieved. And therefore, one could rationalize it as worth doing for even it's a 0.1% profit over a short period of time. And as I say, I'm not sure that we've got the evidence we have to establish the connections with respect to those counterparties. Now, the next transaction, though, which is in a sense where things have gone wrong in this case, if I may say so, is the 2017-004 contract. And this is the one where Mullen Friend and his clients and deponents, and to exempt the judge, have complained that we have taken the chronological series of payments out of their context because of the alleged omission to focus on the payment in from Grand Treasury, or the payments in. But here, if you just look at that transaction grouping, the original contract between the Titan entities and the MaxJoy entity, the contract dates were in April 2017 for quite a large sum of money for bitumen mixture, but payment term within 5 days after handing over the goods title. So Titan entities had to pay within 5 days. Mm-hmm. But then the Grand Treasure entities, at the end of that transaction grouping, who were going to buy it off Titan, although the contract dates are 18th of April 2017, so back to back with the MaxJoy Titan contract, the payments were actually only received, supposedly pursuant to those transactions, on the 15th of December and the 27th of December. And that's because one infers, although one doesn't really understand the timing anyway of the payments, the payment term for those contracts was said to be within 92 days after handing over the goods title. Now,
let me ask, is it accept that the payments were actually received?
I think Mr. Lai accepts that
You produced the bank statements
from Grand Treasure on the bank statements with respect to those sums of money. But the point is, we say that is, in a sense, irrelevant to the proper analysis. Because this now has all the hallmarks of a irregular, and we say fraudulent transaction. Because if it was genuine back-to-back trading, you would have 5-day payment terms for all of the contracts in the group, and the payments would flow immediately. Now, you might say, well, why the delay? Why the mismatch between the 5 days on the one hand and the 92 days on the other? And why the mismatch between April and December? And we submit that that is indicative and supportive of the fraud. Now, the reason for that, and again, it may require a bit of glossing on my part, for which I apologize if it's not clear enough on the evidence that stands, is that by extending that period of credit, essentially, and pushing it back towards the end of the financial year, nobody focuses on that gap in the accounts until much later in time. And so you can divert the funds in the course of the circulation of the funds into, for example, the purchase of the bond by Sino. And by the time you get to December, i.e. a date by which you would have to try and satisfy auditors who do these review of the accounts as at the end of December, you have started a new cycle of transactions that essentially conceals or defers detection of that mismatch. And what we say is it's critical to notice this difference in the structuring of the payment terms and the illogicality of Titan finding itself essentially out of pocket on this set of transaction documents for such a long period of time, unexplained. Now, if you then look at the next contract at page 331, this actually group of transaction contracts was not fully completed because one payment from Titan to MaxJoy, the third payment in the list, was outstanding. But even there, you start seeing some rather odd payment terms in terms of the contract date being 24th of February, but payments being made in May and June, one outstanding. And then so far as the top wind payments to Titan are concerned, again, despite the contracts being February contracts, the payment's not being made until the very end of the financial year, 27th December, 29th December. And in circumstances where actually, even on their own payment term, they were late. So essentially, you're giving unsecured credit to commodities traders in commercially inexplicable terms and inexplicable purposes. You have all these back-to-back contracts, but you're giving them these remarkably generous payment terms. The same is true of the transaction reference below at page 331, 2017-006. Now, in a sense, this is where you end up concealing to some extent the missing monies, because these contracts are now September, later in the year, but they are creating payment terms of 30th of March 2018. So if an auditor was to review the position as at the end of 2017, December 2017, the auditor would say, okay, well, that explains why there's a gap in your cash. There's a cash shortfall because you might not be expecting it until 2018. Now, as it happens, you'll see that the payments are made by Titan before the end of the financial year, December, because the contracts are made in September, but the payments are made in December. So payments all go out. And yet, there's this outstanding payment of the $11 million as at the end of the financial year. But from an audit point of view, an auditor would say, well, where the hell is that missing cash? The answer would be, well, it's not due until the next financial year.
Why would it not be due? Because it says outstanding there. Would the payment have been the 29th of December?
Sorry, so on page 331, the last line entry from Topwind to Titan, they signed a contract on the 18th of September.
Right.
But you see from the right-hand column, the contract provided for a payment term. It will be paid by the 30th of March.
Right, I follow. Thank you.
When we get, though, to the 30th of March, it's not paid. In fact, Topwind is put into compulsory liquidations as insolvent. So that's why it's recorded as being outstanding and the whole transaction is not completed. But just a couple more observations on this document. The Titan obligation to pay MaxJoy that derives from a contract of the 18th of September 2017, in fact, they were given until 30th of March to make the payment.
So why did they make early payment?
Well, precisely. Why did they make early payment? We say that is an indicia of the fraud and the conspiracy, because what they're actually doing is they're pumping more cash out of Titan to this connected party before the end of the financial year. And they would justify it, no doubt, to an auditor or a regulator or anybody else by saying we have a contract that allowed us to make payment in March, but we chose voluntarily to make payment in December. But of course, by making that payment in December, what they're actually potentially doing is facilitating some further circulation of funds. But where you end up, though, on this transaction is with the $11 million not being paid by Topwind by the end of the year and not being payable according to the contract terms until March 2018. Now, there's a slightly similar point that can be made about the next three tables at pages 332 and 333. These are now, though, with respect to the other subsidiary, so they're referred to with transaction references BG 2017-001 through BG 27004. Of these transactions, it's only BG 2017-004 that is implicated in the chronological payment chart set out 51. But of these, you'll see that the first one, although it's recorded as not having been completed, actually was, it started in the period of December 2016 and through to January 2017 for completion dates. That was, in a sense, before the 3rd of April 2017 development with Fame Dragon, And Mercuria Energy appears to be, a company which is not just a paper company. It appears to have a website. It appears to have some substance to it. But this was not recorded as a completed transaction. You then see the next one, BG 2017-002, brackets, purportedly cancelled. So again, a contract that looked like it might be a real contract, albeit with related parties, but cancelled inexplicably and not completed. You then have, though, on the right-hand column, BG 2017.
So just a moment. BG2 was cancelled. Why do you say that this one looks like a real contract in comparison with others that don't?
Well, I don't, in the sense that the parties are all related parties. So in that sense, it's not a real contract. But the payment terms would match up to some extent. But there are some oddities about it in terms of the deposits. Essentially, I'm not really fussed as to whether it's real or not, this one, but it looks like a dodgy one, given its purported cancellation. The timing, though, is December 2016 in terms of the contracts. They have some slightly odd inconsistencies on the payment dates. Anyway, I don't want to confuse your lordship. I mean, in a sense, I think it's best for me to say we don't accept it's illegitimate, but it might look slightly less worrying because it was not completed. But then 2017-004 at 333, this is one of the transactions which falls into the impeached set of payments in the cycles. You have, again, this very inexplicable mismatch between the Titan purchase from Maxjoy of the mixed aromatics with a payment term of 5 days, within 5 days, so 20th of April. And that's part of the funds which we say were then used by Sino to subscribe for the bond. But the payment back is then 92 days after handing over the goods title, with dates in June and November 2017, with a low return date and an as returned. So Mr. Lai, I think, would impress upon me to say to you, and I think he had hoped it was clear enough from the structure of the affirmation with its appendix, that you can group the transactions together, but it's artificial to do so, because what we're actually interested in, bearing in mind the timing of all of this and the coincidence of timing and the mismatch between payment dates, is whether or not there is a proper basis for inferring that the monies used to pay for the subscription, the convertible bond, on the 26th of April, derive from cash extracted from Titan on the 20th of April, which had not been paid back to Titan by the 26th of April, as might have been expected to be the case if they were back-to-back contracts with immediate payment dates. Essentially, they've taken the money out. They've used that money to pay for the bond on the basis that any repayment liability will be pushed off into the future, by which time there'd been another contract putting money back into the system that can be used essentially to defer the moment of the ultimate liability payment falling due, being that Topwind payment. And by the time Topwind was meant to pay, it couldn't pay. And with that effort and explanation put forward, essentially window dressing with a view to avoiding detection by auditors, avoiding detection by shareholders who at this point of time are in a degree of disarray because they're in official receivership with nobody actively scrutinizing the affairs of the companies in which they're invested. It's only when you get the RSM appointees coming on the scene as liquidators in February 2018, they can start looking at the details of these transactions as best they can as they investigate them. The fact that those various companies, we say, are all related and under common control is clearly an important factor to bear in mind when assessing the legitimacy of these contracts.
You said about Grand Treasurer as well.
Yes.
I certainly haven't seen the evidence of the beneficial ownership of Grand Treasurer being related.
Turning to my learned friend, if I may, my lord. This is an area where, certainly so far as the judge was concerned, we're handicapped by the fact that the judge didn't assess any evidence whatsoever.
Could you just repeat what you said quickly a moment ago? The essence of what has gone on, as I understand it, or as I understood what you were saying, is that they've used money provided by Titan in the first of these round-robin transactions at 3-1, when Titan buys purportedly commodities from Max Job. They use that money to enable Sino to subscribe for the bonds. The sales to Grand Treasurer weren't due to be paid for until December. So they've got a period when they've used Titan's money. But then I got slightly lost as to what you were saying about what happened in the end in relation to Topwin. I got the first half of what you were saying, but I didn't get the middle.
Well, I think in that sense, my lord, the best I can do is to, in a sense, invite you to reread the discussion of the circular fund flows that's in the affirmation that, I know your lordship read them carefully because you were asking me difficult questions about them yesterday, but it's really the paragraphs from page 321 to 325. Well, all I can do is wave my hands there and try and sort of do my best to graphically illustrate my understanding of it. But my understanding is, if the companies are all connected and they're all going around in a loop, while there may be some evidential gaps in the loop because we don't necessarily have the totality of all of those other companies' documents, the inference to be drawn is that they have been circulating the money in such a way that they can keep funding these contracts on their face by pushing off the repayment dates until the end of the financial year or the next one. And in a sense, whether it's a game of musical chairs analogy or some other Ponzi scheme analogy, robbing Peter to pay Paul, it's only when it stops that you identify the fact that there's money missing from the cycle. And
only when it stops, what's it?
The cycle. And in a sense, had Mr. Waving and Tang remained in control of the company, they could have carried on recycling the money around and again. Because every time an auditor came along and said, why is there missing money at the end of a financial year? They would say that's because there's another contract that's been entered into that pushes off that repayment into the next financial year. And so unless the auditors would carry out an investigation to say, oh, well, hang on, who's this related party? If on its face, it appears to be a different company in BVI without any obvious indication of who its owners are, the auditors might just say, okay, well, it looks like an arm's length transaction. We're happy to essentially roll over that liability into the following year. So for as long as they're in control and the auditors are being satisfied by the fact the next round of transactions has pushed off money being due, it never gets detected. The only reason it gets detected is because there's a change of control. So new management come in saying, well, hang on, we're not going to enter into new contracts, but we want payment by Topwin. And they go to Topwin and they say, please pay this amount due. And Topwin says, sorry, we've got no money to pay you. Even though, in a sense, Topwin should have been sitting on some commodities which they should have sold to somebody else who could have paid for them. So that's why it's at the moment in time where Titan, with new management, petitions for top wins winding up for non-payment, that the loss is crystallized. And so far as the liquidators' point of view is concerned, it's a remarkable coincidence that the amount of money that Topwin is left owing is very similar to the amount under the convertible bond, which has leaked out in April 2017.
Well, it's significantly more, isn't it?
Yeah, but it's more as well. But they explain the differences and they try to reconcile the differences. But obviously, I mean, in any case of fraud, my lord, or conspiracy, you are at the end of the day still relying on many strands of circumstantial evidence, of inference, of coincidences, unexplained coincidences, and the lack of explanation. So this whole case could have been dispensed with and avoided if Sino, when asked what the source of funds were for subscribing for the bond, if they had just done the simple thing of saying, you guys are just barking mad, whatever coincidences you see in all of these facts, here is clearly verifiable information and documentation to support the fact the money was invested from some completely unrelated source.
But the Sino says it wasn't a party to these trading contracts.
I know that's an even more remarkable fact in this case. We've shown you the trading contract documents which they signed up to. And they say those contracts, implicating them in the loop, they never even signed. They said they're forged. Of course, at a trial in Hong Kong, it would be a complete answer, not only to show the funds came from a completely unrelated source, but that in fact Sino had nothing to do with this trading circuit. But we would say at that trial, well, that's quite a serious thing to be alleging if what you're alleging is these documents which show that you were forgeries.
I'm so sorry, which are the documents that Sino signed, which they say are forgeries?
Well, I mean, eventually Mr. White can perhaps articulate his client's case more clearly, but so far as the evidential exchange in these proceedings is concerned, in our evidence, we exhibited those sales and purchase contracts, including the ones we saw yesterday.
Remind us of where we find it.
Okay.
The reason I'm asking the question is that I'm looking for the 18th time at flowcharts 1, 2, and 3, and I can't, as a present advised, see that there is something where Sino signed the contract.
I'm sorry. Well, if you look at 321,
Yes. I see. Step A3. Yes. Are those two said to be forged?
So in step A3, there's the cross-reference of those two contracts, bitumen mixture and mixed aromatics. Now, if we want to look at the reference in terms of the trial bundle reference, the trial bundle reference should be at volume D for Delta, D1, tab 43.
Mm.
And if we look at the page 1357, D1 tab 43, page 1357. What you'll find there, and I think I showed it to your lordships yesterday, was the sales and purchase contract in this group of transactions,
Yes.
which is a sales and purchase contract between Sino and Uniloyal, which on the right-hand page at 1358 appears to bear the Sino signature or the stamp.
And that's said by Sino to be forged, is it?
Well, in these proceedings, in the evidence filed in these proceedings, Mr. Zhao says nothing of that sort.
Right.
He's silent about it. So we would say, as a matter of evidential inference, if you're dealing with conflicting evidence, and we say you, Sino were part of this circuit, and you're silent in your evidence on that point, it is to be inferred that we're correct in the absence of a contest on that issue. But in the Hong Kong proceedings, in the defense I showed your lordships yesterday, they are now positively averring in a defense in Hong Kong that they had nothing to do with these contracts. They weren't even part of the loop.
Right.
The inference from that, whether they use the word forgery or not in their defense, is that the case that they would like to run before the Hong Kong court is one, that they received the finance to pay for the bond from some entirely unrelated source. It had nothing to do with Titan. It never came from a Titan subsidiary.
It is.
So that's the point. Coupled with the second point they want to advance, which is, and by the way, we Sino are just an investment business, in the investment business of investing in bonds, but we're not a commodities trader.
Yeah.
And we never signed up to a commodities contract. From which we say, well, those are stark evidential issues that require a trial, but a little bit unlikely on the face of the documents, given that we've got Sino signature to these contracts. Now, for what it's worth, I mean, just so I can understand the provenance of those documents, they're referred to, I think, in Mr. Zhang's affirmation evidence, because even the provenance of them is, in a sense, unexplained. If you look at volume C and go back to tab 24, page 197.
197.
Page 197 of volume C, the affidavits.
Yes.
In Mr. Zhang's first affirmation, he said at paragraph 51, I should add that I first discovered the first and second uni-Sino downstream contracts, as well as the aforesaid invoice issued by Sino when I received them from Titan staff who found them amongst Titan's... Page 197 of volume C.
Paragraph 50.
Paragraph 57.
I'm sorry, my lord. 197 page,
Yes.
paragraph 51.
51.
And what was said in that paragraph to explain the provenance of the documents is that Mr. Zhang, by now the executive director, first discovered these contracts as well as the invoice issued by Sino when I received them from Titan staff who found them amongst Titan's transaction records. I found this very surprising, as the Titan Group itself was not party to those documents. It seems to me that the aforesaid documents could only have been in Titan's possession because Wei Bing and Tang, as the controllers behind Sino neglected to take them away when they departed from the Titan board. And in a sense, it's not a sort of surprising thing to say, because it is a bit odd that if you had arm's length commodity transactions between unrelated companies, why would Titan's new management get access amongst Titan papers to copies of a contract between Sino and Unilog, unless the people who were in charge of Titan at the time were privy to that material? And as I say, in these proceedings, they haven't denied the existence or the veracity of those documents. It's only in the Hong Kong proceedings that they assert that they had nothing to do with any of it.
Right. Going back to where we were before, we're almost there, I think. If you go to paragraph 320, I'm so sorry, page 326 of Volume C, at tab 29, you have at paragraph 54 the conclusion of Mr. Lai, who says, in short, the above shows that the subscription money of the convertible bonds was sourced from the Titan Group. As a result of the $78 million Hong Kong dollars, or 10 million US dollars, being applied for the subscription of the convertible bonds during the rounds of round robin, well, it's in the first round, the $10 million for the purchase of convertible bonds, plus 0.64 United States dollars million retained in Top Win or Uniloyal, that's in subsequent rounds, which were taken out from the commodities trading transaction chain, were finally outstanding and became a bad debt. Now, I broadly understand what he's saying there. The difficulty that I in part face is that that appears to assume that there's a limited amount of funds that go round in a circle, but in the end, leave a bad debt because as part of the circle, monies have been used not to pay for commodities, but to pay for the bonds. I would understand that readily if we were dealing with a circle composed of two persons, but here we've got a number of different companies who pay from different bank accounts. And I'm having a little difficulty in getting my mind around the idea that there's in effect a limited amount of funds, so that if there's any payment which is not for a commodity, there will in the end become a bad debt, given that we're dealing with about 5 different companies paying money from 5 different bank accounts.
Well, all I can say is this is the critical absence of the judge's judgment, because we have all the evidence in our affidavits that explain the common control and ownership of all of those companies by the way being attacked.
Right.
And in a sense, my lord, if your experience of commodities trading is perhaps the London market, it's one thing. But we're in Hong Kong and China, with everyone using these paper BVI companies who set up a bank account with no public disclosure, no regulatory oversight. It's in a sense, the easiest thing in the world to do, to set up 5 companies to conceal your trading, rather than just doing it with one company. And all these indicia that Mr. Lai, as a forensic accountant with experience of fraud investigation, is pointing to are just hallmarks of this.
Because so really what you say is there are 5 different companies, but they're all under control of the same person. So one can really proceed on the basis that one's dealing with one company. They engage in these commodities transactions to make it look as if they've got a thriving commodities business. That's okay, provided they sell what they buy and buy what they sell. But if what they do is use some of the money from the commodities transaction to pay for that which is not a commodities transaction, you get a minus figure in the end, because if you buy and sell, always it's a profit, you never lose any money. But if when you get some money, you use half of it to pay something else, at the end of the day, you'll get a bad debt.
That's, in a nutshell, what Mr. Lai has tried to communicate and Mr. Zhang to the court.
I can only work on nutshell.
And in a sense, my learned friend's criticism of all of that is it is subject to confirmation bias, and he would want to interrogate Mr. Lai with all these forensic points about, he's looked at it wrong under a telescope. But we would say, well, actually, it's true that when you eventually end up in a trial in Hong Kong, there will be forensic accounting evidence from independent experts. And no doubt in their reports, they would have to say, here's the company's version of events based on the cash accounting that it's reconciled through Mr. Lai. An alternative scenario is you don't look at the cash accounting, but you assume that the contracts are all legitimate. And therefore, what you do is you reconcile each group of transactions the way he's done in his appendix. But at the end of the day, it's up to the court to decide whether we're dealing with crooks or innocent arm's length parties who've got an innocent explanation for all of this. And to criticize Mr. Lai for the purposes of these proceedings, where we're simply defending a winding up petition based on the statutory demand, can't possibly be expected to bring forward the totality of the forensic independent evidence you might get if you commission FTI, is a criticism too far when you bear in mind the threshold, which is just arguability. And if I may, it may be helpful to finish off on this point to try and answer my Lord Justice Peel Smelly's question about that Grand Treasurer, I think, connection. I think it's dealt with in the affirmations, but it may just be helpful to illustrate it by reference to documents. So I think volume D1, please.
D as in Delta.
E as in Delta. So this is an exhibit to Mr. Zhang's first affirmation. If you turn to page 1138, please.
Tab 43.
Yes, tab 43, 1138. What I hope you see at 1138 is a document from the Hong Kong Companies Register, I think, relating to Max Joy. And the bottom, I think you'll see that the presenter or the incorporator is Lu Young, with an address in the New Territories in Hong Kong. And then if you look over the page 1140, you'll see that the company secretary, Lu Young, is entered in the data at the top of page 1140. Look over the page, you'll see that Mr. Ku Wai Hong, is entered as one of the directors of that company. And then I think the document is signed by Ku Wai Hong. And you get to then page 1145, where he's recorded as the shareholder for the non-listed company. So that's all Max Joy. But if you turn over to page 1147, you'll see that Grand Treasurer's documents now appear. So top of 1147, Grand Treasurer.
What's the point of taking us to 1140 to 1145?
Well, this is, I think, explained by Mr. Zhang in the affirmation to try and explain the extent of the evidence we have from which you draw the inference that they're all under common control. The stepping point is, if I show you the Grand Treasurer document first rather than second, you would say, well, what does this show? I'm showing you the Max Joy one first to show you the names of the participants, including Mr. Ku.
Max, we have the two names.
So we have those names. Now, if you look at 1147, you'll see Grand Treasurer's documents. At the bottom of 1147, you see the same address. And on 1150, you'll see the same Mr. Ku. And 1154, the same.
1150, you'll see the same.
Page 1150.
Yes.
You'll see the same name of the director who was on the Max Joy document as being Mr. Ku.
Mr. Ku, I thought it was Mr. Shu. Yes.
I'm sorry, my lord. Mr. Ku.
Yes.
And then again, at page 1154, you'll see Mr. Ku and Mr. Lu on the Grand Treasurer documents.
Yes.
And it may just help me to find the passage in Mr. Zhang's affirmation that deals with the common connections, which these are the exhibits.
Why is it finished that these two companies have two common directors?
Because if they were independent arm's length commodity traders, why would there be more than one of them? Yes. So when we look at the transaction chain, Max Joy and Grand Treasurer are counterparties to commodities transactions. So they're self-dealing between themselves. So again, this is best looked at in the evidence of the deponent, so Mr. Zhang, I think if you can look back at volume C, page 186. So if you look at page 186, under part of the evidence about common control, you'll see that paragraph 2, there's a subheading Max Joy. Max Joy was at all material times a Hong Kong private company wholly owned by Tang's friend Ku Wai Hong. Max Joy and its controller Ku Wai Hong were in fact pawns passively following the instructions of Tang. There's now produced and shown to me a true copy of the annual return of Max Joy, true copy of WeChat messages between, amongst others, Tang and Ku Wai Hong. By early 2017, Tang and Ku Wai Hong had been trading partners in the oil trading industry for some time, would like to expand their trading with the help of other business partners. In the exhibited WeChat messages, Tang spoke to group persons, including Wei Bing and Ku Wai Hong, about oil trading opportunities offered by another company. Tang told the persons of the WeChat group that Ku Wai Hong had many resources in the oil trading industry and would very quickly link together downstream buyers and upstream sellers for trading purposes. In response, in a WeChat message dated 2nd April 2017 of Tang, Ku Wai Hong said he would follow the orders from the leadership, referring to Tang. And then, most recently, in correspondence exchange between Titan and Max Joy on 11th of 18th of October 2019, Max Joy confirmed the transaction in the Titan Group and Max Joy were, and then Chinese script, my understanding being the transaction was merely a conduit for the flow of funds for unknown third-party purposes. And that many details concerning Max Joy's transaction with Titan Group, including the identity of the upstream seller and downstream buyer, were determined, nominated pursuant to Tang's directions and arrangements. They're now produced and shown to me at certain pages, true copies of the list of confirmation. From investigations, it seems to me that Max Joy and Ku Wai Hong were only passively following Tang's instructions until Wei Bing and Tang's wrongdoings came to light. It appeared that Max Joy and Ku Wai Hong were not aware of the nefarious intent or purposes of Wei Bing and Tang.
Yes.
So there's quite a bit of further discussion of the relationships, I think, between the parties in Mr. Zhang's second affirmation. So if you were to look at the next tab at page 278, page 278, paragraph 60, you'll see there at 60, he said, Sino has conveniently omitted to mention that Grand Treasure was a company controlled and owned by Ku Wai Hong. And the court has referred to some of those pages in annual returns. You can see that Ku Wai Hong was an 85% shareholder of Grand Treasure. And paragraph 2, if which is denied, the goods did change hands under the Titan Group, Max Joy contracts and Grand Treasure Titan Group contracts, those contracts would clearly be self-dealing transactions, with Ku Wai Hong, in essence, selling goods to himself. This trading pattern should ring alarm bells.
Right.
So, again, I'm not saying I can put it as high today that I have a direct witness of fact or such smoking gun evidence that one could possibly not have a trial of these issues. But the judge completely ignored all this evidence about common control and links between the parties, whether it's the WeChat messages or the corporate filings and everything else. He completely ignored all of that.
Mm.
But we say it is supportive of the indicia of this being a fraud.
Yes.
I hope I've done justice to the evidence, but as I'm sure your lordship appreciates, there's probably buried in these documents even more materials cross-referred to in the affidavits.
I'm sure there is.
But I'm anxious, obviously, not to spend too much more time on my feet. My lord, can I just double check if I had anything else to try and answer your lordship's questions about?
No, thank you very much for doing so. I'm sorry that my mind has compelled you to do so.
Unless I can assist your lordship any further, those are really my submissions for the appeal. There was one debate or discussion yesterday about theoretical scenarios in a proof of debt procedure, and that provoked some instructions overnight about how unworkable that would be. But I think your lordship's already had that point, and if necessary, I can come back to that in reply once you've heard from Mr. White.
Right. Okay.
My lords, those are my submissions to support the appeal. Thank you.
Thank you.
Yes.
My lords, I'm conscious of the time. I'll try and be as succinct as possible in my submissions. The court already has the benefit of a fairly lengthy skeleton argument.
Can I try and be as succinct as possible as well? A couple of days were spent before the Chief Justice. A couple of days would have been spent before us in determining this case, none of which would have been necessary if Sino Charm revealed the source of their monies with which they subscribed to the bond. What in fact has happened is that Sino Charm has said it's none of your business. That seemed to us slightly curious.
My lord, in terms of that point, I had intended to address it, but since you've raised it at this stage, I'll deal with it.
Well, I don't want to take you out of order, but it seems to us quite important at some stage.
My lord, from the perspective of the petitioner, it has followed the route of serving a statutory demand. And Mr. Potts has taken us to some of the correspondence, where in relation to the statutory demand, there has not been an effective dispute on the debt. My lord, that's encompassed in the Chief Justice's judgment, really on the basis that what they say is they ask for time to investigate.
Yeah.
They don't raise the defence which they raised in Hong Kong in October 2019, or in the affidavit of Mr. Zhang, also in October 2019. And there is radio silence from the company from the 12th of August onwards, which is the reply letter to Congress from Appleby. So in those circumstances, they put forward the petition, as one would expect, setting out their debt, setting out the statutory demand, setting out that this is deemed insolvency under section 161E of the Companies Act, and dealing with and exhibiting the correspondence from the 2nd of August and the 12th of August 2019. Now, they're entitled to do so in those circumstances because no defence has been raised. No further steps have been taken by the company of the nature one would expect if there is a genuine dispute. My lords may have noted from some of the case law referred to, typically we see these kind of disputes dealt with on applications for injunctive relief. So if you have as a company, a genuine dispute, you would seek an injunction restraining the filing of a petition. Or if it's too late, an injunction restraining the advertisement of the petition. Or after that, striking out. Or even just in accordance with the Bermuda winding up rules, to file an affidavit in opposition within 7 days. Now, none of that was done. What is raised by the company in the manner that the judge found to be retaliatory, they don't engage with the Bermuda court. They go to Hong Kong. They file proceedings on 21st of October 2019, and then file Mr. Zhang's affirmation setting out their defence a day or so after. And that is a defence which has a fundamental flaw in it. And I'll spend some time on this in due course. But just to headline it now, exactly as the judge found in his ruling, there has been a misleading impression created in the company's evidence. And the focus here is on the company's evidence, because it's the company who is demonstrating.
Forgive me, that's all very interesting, but it doesn't actually answer my question. The position in front of the Chief Justice is that he had to determine whether there was a reasonable, bona fide reasonable defence. The defence being that this was all a fraudulent transaction because, in effect, Titan produced the money for Sinocharm to pay the bond back, to subscribe to Titan's bond. That was the issue that the Chief Justice had to decide. He decided in your favour. There's now an appeal, and we have to decide whether the Chief Justice was right, or whether if he wasn't right, what the position should be. none of that dispute would be necessary if if Sinocharm, as on its case it must be capable of doing, said this is all nonsense. We subscribed from monies which we derived from the investors. Here is the transfer from one bank account to another, or even a check, which shows what we did. Please go away. But nothing of the kind has happened.
So it's not their business.
My lord,
You said it's not their business, and it is our business.
my lord, the reason Sinocharm says, well, it's none of your business, is because this is an argument, a defence being raised by the company, for the company to demonstrate that it has a bona fide dispute on substantial grounds. Now, this is effectively being turned on its head for tactical reasons by the company, to say, well, no, you as the debtor, you prove. They reverse the burden. They say, you prove where all your funds have come from.
Well, that is at the very least unhelpful. On that footing, we have to go through 4 days of evidence when your clients, if they're correct, sort of obviated the whole thing in 20 minutes.
My lord, Mr. Zhu, in his evidence, in his first affirmation, does deal with source of funds. And source of funds is the heading used by Mr. Zhang in his first affirmation. And Mr. Zhu does respond to that. So I can take you to Bundle C and tab 25.
Yes.
Apologies if it's page 241. Now, my lords, I should preface this by just drawing your attention. I'll come back to paragraph 29 in due course. But paragraph 29 in the preceding paragraphs deal with the issue of the downstream buyer contracts with Grand Treasury and the effect of their emission. And then we come in at the top of page 241. As illustrated above, it's apparent that the subscription agreement was not funded by money from Titan Group, contrary to Titan's current contentions. In this situation, Sinocharm's source of funds is quite simply none of Titan's business. However, in order for the court to gain a better understanding, I will elaborate on Sinocharm's ability to finance such an investment. And he goes on to say, Sinocharm is an investment company which has been funded by a number of seasoned and reputable investment professionals. And then we have Mr. Yan, Ms. Chen Zi, and Mr. Wen Sheng. And there's some further information given about those particular investors underneath. So he's saying there's a number of investors. 3 are prepared, in effect, to waive their confidentiality and put their heads above the parapet. And they are significant business people within the Chinese business world. My lord, having put their heads above the parapet, in paragraphs of Zhang's second affirmation, which was struck out.
You're leaving Zhou at this point. What is not said here is how they injected funds into the company, into Sinocharm, so that it could pay the monies to the company.
My lord, what that would entail would be identifying all the various investors, showing all the money coming into Sinocharm, detailing disclosure of Sinocharm's accounts for the purposes of reversing the burden of proof, putting the onus on the petitioner.
As my Lord President has pointed out, it does actually go straight to the point and provide a very simple answer. But I thought you were going to show us where it happened, and as yet, all you've done is say that these are very wealthy people behind Sinocharm.
See, it's even simpler, because what is said here is that there are a number of wealthy investors. They put money in Sinocharm, and then at 31, what's being said is nonsensical and ignores the fact that Sinocharm has, as would be expected, an investment company, a number of different investors. The fund used by Sinocharm to subscribe the bonds came from this investment capital. So the investors put their money into Sinocharm, fine, and then Sinocharm must have been able to show how they paid for it, and that it was part of their investment capital.
My lord, my opening submission says it's quite a peculiar circumstance to expect company having loaned another company money to give detailed disclosure of its financial circumstances, including the identity of its investors, and tracking back all the various sources of funds. Now that was a red herring put forward by the company. But my lords, we are dealing here with BVI Incorporated company, with a nominal director and shareholder in the form of Mr. Chandler. And the court will know from its own experience, there's nothing unusual in that. There's a particular reason why BVI has enjoyed a boom of incorporations, and indeed attracts money from China and that part of the Far East. And the importance of that is confidentiality, and indeed a degree of secrecy around who provides the money. And my lord, as I set out in my skeleton argument at first instance, that has been judicially noted previously in Bermuda. My lord, in fact, in the earlier Titan Petrochemicals proceedings in 2013, I can hand forward a copy of the authority
I
referred
must say
to.
right away, I don't find at all an attractive proposition. But shouldn't you be mindful of the fact that when you talk about reversal of burden of proof, that here we are talking about people who had a close connection with the company which they now seek through Sino to wind up, and that there are allegations of conflict of interest. Wouldn't that be a proper basis on which to dispel any such concerns about source of funding?
My lord, that would be working on the assumption. It's an assumption put forward by the company without evidence that there is a connection between Sino and the company. My learned friend puts forward this argument based on control. But the weak link, a number of weak links there are, but in this particular weak link, is there is no evidence of control of Sino by Dr. Wei Bing or Mr. Tang. Indeed, the appellant uses them interchangeably. It could be Dr. Wei Bing, it could be Tang, it could be a combination of the two. But in terms of the point I was coming to, if one looks at the decision in the first round of the Titan Petrochemicals litigation, it's paragraph 8. And this is I think, from the ruling of former Chief Justice. And halfway through the sentence, the Chief Justice says, I accept that the existence of confidentiality.
Where is this in this judgment? Sorry.
Paragraph 8.
Paragraph 8.
And halfway through, it begins, I accept that the existence of confidentiality agreements is a plausible explanation for this reticence, because it is, I think, a notorious fact that investors in China are generally very concerned about confidentiality. So it is not surprising, in a sense, that a company being asked to disclose information, as it were on a voluntary basis, as part of a contested winding up period, has not found itself able to do so to the extent that might otherwise be the case for a company with a centre of gravity in another part of the world. So, my lords, we have judicial notice of the fact that I adverted to.
Which you seem to want to extend to a principle of general applicability.
My lord, I take it no further than the Chief Justice does. It's a notorious fact. It's something this court, and indeed the Chief Justice below, could take judicial notice of. And he was invited to, in terms, as far as it was relevant, in the skeleton argument of the petitioner below. And my lord, it may seem a simple answer, well, can't we cut through this with some proof of funds, some source of funds evidence supplied by the petitioner? My lord, that is it's a rhetorical question. What has a rhetorical answer? The extremely aggressive stance taken by the company. As I say, the identities of these three investors are revealed at paragraph 30 in Mr. Z's first affirmation. In Mr. Zhang's second affirmation, there is page after page of personal attack on each of these investors. It is readily understandable why this form of disclosure would not be given. And there's no need to, because it is the company. My own friend took us to the extract from McPherson. It is the company which must demonstrate.
That seems to consist of all held short of assistance.
My lord, sorry, I can't.
That seems to consist of all held short of assistance.
My lord, I didn't think I could put it any other way, but it's quite a significant thing, to be honest, for all that confidentiality to be waived.
Well, I'm not going to follow this. They're prepared to reveal the three major investors are Yoon, Chen, and Wu, so that confidentiality is gone, but not to explain any of the mechanics by which the investment came in and the payment went out.
My lord, there's just three of the investors, and not even said they're the major investors. They are three of the investors who have agreed to have their names mentioned in this affirmation to address a point that Mr. Zhang has raised. And it's really the world turned upside down to expect a petitioner to disclose extensive, and it must be extensive, financial disclosure in order to assuage a point on what is, when properly
But actually, why it's so sensitive when you've essentially got an admission that because of these three wealthy investors, there's an investment fund. How does it hurt to show how the money went from this investment fund into the funds?
My lord, there is perhaps an assumption there as well that may come from my learned friends' submissions and written submissions. It's suggested that these are the only three investors. That is not the case, and that's not what Mr. Zhu said.
I wasn't bothered about whether there were three or more. The question is, they are identified, and it's identified that there is an investment fund. So what is the hurt in showing the documentation which shows the money coming from the investment fund to the company for the bonds?
My lord, because that would involve waiver of confidentiality and extensive disclosure
But
of
isn't that
financial
bound to happen ultimately in Hong Kong proceedings?
My lord, of course, at the point that Mr. Zhu is giving this evidence, and it's important to bear in mind the context because we have a petition proceeding.
Can you give a yes or no to that question?
My lord, I think I can only answer this way: that the petition proceeding, the Hong Kong proceedings, weren't served on Sino for a year. They weren't a significant fact for the petitioner in October 2019. And my lords,
the question was simply whether or not this information would necessarily be disclosed to the court, the Hong Kong court, when those proceedings came off trial.
my lord, I don't know. It may be covered within the ambit of disclosure, or
Wait
it's.
a minute. You say you don't know. The rules of disclosure in Hong Kong are pretty identical to the rules here and in England. Disclosure at the lowest requires the disclosure of all relevant documents. In a case such as this, where the fraud of which we're all, the nature of which we're all aware is asserted, it would plainly be irrelevant all documents which show that Sino in fact paid for the bond with monies which had no connection with Titan would plainly be disclosable. Would they not?
But that,
And one would have thought essential to China Chan's case.
my lord, again, we're looking from the far end of the proceedings, where things stood in 2019, when this evidence was being given. I think actually it was,
I follow that. So what Justice Bell was asking was whether these documents would be disclosable in the Hong Kong proceedings. You effectively said you don't know, and I suggest that can't be right if you think about it for more than about 20 seconds.
my lord, it may be within the scope of disclosure. But what is being suggested is that the thought process would have to be this for Mr. Zhu in 2019. There are some proceedings filed, but not served. At some point in time, if those proceedings were to continue, on a matter of disclosure, we would have to disclose these documents.
You say filed and not served, but we know matters have moved on. We've been shown pleadings in the Hong Kong proceedings.
My lord, yes, and that is because the petition proceedings have become very truncated. They were originally supposed to be dealt with fairly swiftly. The original hearing of the substantive issues was listed and adjourned on the day, on the 21st of February, 2020. Now, of course, we have COVID intervening, and then we have, as set out in Mr. Zhu's evidence, in the seventh affirmation, delay caused on the part of the company. And my lord, it can't be right simply by the effluxion of time, because it's taken a long time for the matters to be got back to court. When the delay is partly due to the company's own conduct, that it be said, well, the Hong Kong proceedings are therefore of central significance. Because, my lord, I can see why that's argued by the company in July 2021, because nobody anticipated it would take so long to bring these matters back. When they were adjourned in February 2020, the directions order provided for a rehearing to be listed in about April of 2020. And the majority of the issues that my learned friend now raises in relation to the Hong Kong proceedings simply didn't exist at that time. And my lords, this in my submission shows the fallacy of the argument. So I can see, my lord, President Clark's point in terms of disclosure. If one were effectively weighing it up, well, should we disclose in Bermuda? Because we're going to have to disclose in Hong Kong. But in my submission, that's a false choice at that stage. And I hope I've explained the chronology of the proceedings sufficiently to make that point.
Right.
And my lords, in terms of disclosure of any underlying documents from Sino Charm, I don't want to repeat myself. I've said there's a high degree of confidentiality that is being attached to this. And if it was a case where it absolutely must be disclosed, well, that might be a different situation. But what was being looked at here, from the petitioner's point of view, was a hopeless, dredged up defence, which did not require the drastic action of the disclosure of all its investors, all the sources of funding, and the payment to Titan. And my lords, to bring that back to the appeal, and of course, we're looking at the grounds of appeal put forward by the company, or by its former directors, I should say. And there is no ground of appeal in relation to the particular point that we are dealing with here. It is not said on appeal that the judge failed to have sufficient regard to the lack of disclosure by Sino Charm of its source of funds. It's not a ground of appeal. In my submission, it's not properly before this court.
Actually, if you look at 2.1 and 4.2 on rapid definition of the is
2.1.4.2.
sorry, 2.1.4.2, page 38.
My lord, this is one of the matters I was going to take you to. So we actually read this. And I think first you need to take cognizance of the one before, 2.1.4.1, because the ground of appeal my learned friend refers to is parasitic on the first ground. And 2.1.4.1 is a ground of appeal which has been abandoned by the appellant. It is the undisputed fact that funds from Titan Group were transferred to Sino Charm. So it was being put forward as a ground of appeal that it was undisputed below that Sino Charm had received money from Titan Group in relation to the Unioil contract. Now that was a surprising ground of appeal to take, because the position of the company below is, as Mr. Potts has stated it to me yesterday, that actually there is an issue of dispute between Sino Charm and Titan as to whether there was any commodity contract with Unioil and any payment.
In a commodity contract. Well, okay, so we should cross out undisputed
My lord, yes. So
But that doesn't mean the rest of the paragraph is OTS. The alleged facts for funds from.
well, no, my lord, I think the entire paragraph does.
Why?
What the appellant was saying is there was an undisputed fact the judge ignored. It turns out it wasn't a undisputed fact. A point recognised by my learned friend below, and now recognised by on appeal in his oral submissions. And effectively, this section is abandoned. But if we then go on to look at 2.1.4.2, it said, despite numerous invitations, Sino has never explained in evidence or in correspondence how the funds received from Titan Group were deployed. So this is on the basis that money has been received from Titan Group under this flow fund, which, if you recall, comes to the position of a commodity contract between Untitled and Sino. And this ground of appeal then asks, well, Sino was never explained how that money was deployed. That is not the same question that my learned Lord President asked me some 15 or 20 minutes ago, which is about the source of funds for Sino. This is asking about how money received from Titan Group was deployed. And it's a false ground of appeal, because it acts on the assumption that money was received, because there is an undisputed fact that there was a commodity contract between Untitled and the petitioner under which money is being paid. Now, it's a convoluted point in the grounds of appeal. And my lords, the respondent has made the point that the grounds of appeal are prolix, difficult to understand, and rather scattergun in their approach. But I think that the point that Mr. Potts is just trying to make underlines this. There is no ground of appeal that goes towards any purported failure by Sino to reveal financial documents. It's simply not there, my lords. It's not before this court. And as I say, it also does tend to reverse the burden of proof. Now, the burden of proof, as it was put to the judge below, which wasn't controversial below, was that the burden is on Tyson. My lords, if I can ask you to take up bundle H, the authorities on
Yes.
go to the back of that and to the extract from McPherson.
What tab?
I apologize, it's tab 41. 24?
41.
Sorry, 41.
41.
I'm afraid my voice may not carry. I'm conscious of the two
Well,
or three person screens.
the screens between the I know, I have a shout at each other. I think. Don't take the miss. Yes.
My lord, sorry, I've just lost my place. Yes, under 3080, and just after 748, the footnote. Courts have in the past generally said that the company is required to demonstrate that the dispute must be genuine and bona fide, both in the sense that it must be honestly believed to exist by those who allege it, and in the sense that the belief.
I'm sorry.
Where are you reading my lost?
I do apologise. It's 3080.
Yes. Yes.
About halfway through that
Yes.
first paragraph.
The courts have in the last, yes.
There is a rather prominent footnote, 748.
Right.
Certainly. It says the courts have in the past
Mhm.
generally said that the company was required to demonstrate that the dispute must be genuine and bona fide, both in the sense that it must be honestly believed to exist by those who allege it, and in the sense that the belief must be based on reasonable or substantial grounds. And it then goes on to say the various descriptions given to the kind of dispute that must exist is rather confusing.
Yes, that's true.
My lord, you may remember there was when we looked at French, a rather long section,
Yes.
dealing with the way it's various different ways.
Real and substantial, real or substantial, does.
My lord, but it's for the company to demonstrate that the dispute must be genuine and bona fide.
Yeah.
And if we go 2 paragraphs down, it said whether or not there is a dispute on substantial grounds is a matter to be decided in each case, which of course the Chief Justice recognised in his judgment and is accepted in paragraph 37 of my learned friend's judgment, that it is a question to be judged on the facts of each case. Now, my lords, in terms of that burden, there's also assistance from French. And there are 2 versions of French that appear in the bundle. I can take it to tab 44.
Tab 44, yes.
And this is the 3rd edition of French. My learned friend took you to the 4th edition yesterday. This was the edition before. And if we look at on page H750, paragraph 7.451, it says most courts have held that the onus is on the company to prove on a balance of probabilities that the debt is disputed on some substantial ground. This applies even if the petitioner alleges serious fraud. Some courts have held that the onus is on the petitioner to show that the dispute is not sufficiently substantial. The test of substantiality is sometimes expressed as if the onus were on the petitioner. It is submitted that the onus must be on, which is the applicant, and is the party asserting the existence of a dispute. And that was the way the burden of proof was put before the court. Now, my lords, in the Chief Justice's ruling, not much really turns on the burden of proof. The judge has looked into all relevant factual circumstances. But if we go back to whether there needs to be disclosure by Sino charm, Sino charm is proceeding on the basis the burden is on the company. It's for the company to demonstrate its grounds, not for the petitioner to have the onus of disproving. And my lords, there is a curiosity we then get with the 4th edition, which, as I say, wasn't available to the court.
Yes.
And my lords, the 4th edition is at tab 42.
Is that
42 or
do you mean 46?
what is 45?
Yeah, 45 too as well. Oh, is it? Oh, I see.
Saw it at tab 45 yesterday.
43 and 40. If you wanted a 42 paragraph.
My lords, I may have sent you in the wrong direction. I do apologise.
Don't you mean 46? No, well, no, 45.
Yes, that's the one we were referred to yesterday.
45 says French, 4th.
I said it's 43.
The 4th edition is at 45. You were referred to 7.577 and following yesterday. The test.
It'll be 45.
No, this is sorry. So what should we look at that in the 4th edition?
I'm grateful for my then friend's assistance. It's tab 45.
Mhm.
And section on burden of proof on page 759
Mhm.
is there is a change of nuance at 7.587.
587, okay.
It says on an application by a company to prevent presentation or continuation of a creditor's petition, the applicant company has the burden of proof that the petition debt is disputed on substantial grounds. The petitioner then has the substantial burden of showing that it is more likely there is no dispute on substantial grounds. On hearing a petition, the burdens are reversed because being an undisputed creditor is an essential element of the petitioner's case. So in French, in the 4th edition, a distinction is being drawn between the company as an applicant, so on a strike-out application, or an application for an injunction, and upon the hearing of the petition. Now that's an oddity because, of course, in the 3rd edition, there is editorial comment that the onus is in fact on the company. Now one would usually look in these circumstances to see if there's been a change of law in the intervening period and further cases. But the footnote 1426 doesn't refer to cases since the 3rd edition, which is in 2015. It refers to a 1991 case.
How are you saying this statement is not correct?
My lords, I can only draw your attention to what it says. There's a very clear editorial comment in the 3rd edition that appears to be nuanced in the 4th edition, which my learned friend took you to yesterday, and I feel obliged to address. But the long and short of it is, in terms of the burden applied below, there was no controversy between the parties, and it was the 3rd edition that was referred to.
I'm sorry, I'm lost by what the authors say here. Well, an application by a company to prevent presentation or continuation of a creditor's petition, the applicant company has the burden of proof that the petition in debt is disputed on substantial grounds. Well, that's because the applicant company is there seeking an injunction to prevent presentation. Petitioner then has the evidential burden of showing that it is more likely that there is no dispute on substantial grounds. Don't quite know what is meant by that. I mean, the evidential burden means that you've got to produce some evidence if you're going to get home. But if the position is that the applicant company has the burden of proof that the petition debt is disputed on substantial grounds, then it's got to produce evidence to that effect. The petitioner will then have to produce some evidence to the contrary, but I'm not sure that that means that the petitioner then has the burden of showing that it's more likely that there is no dispute on substantial grounds. I would have thought that in the light of the totality of the evidence, the court had to decide whether the applicant has shown that the petition debt is disputed on substantial grounds.
My lord, yes, it makes logical sense because it is the defence being raised by the company, which is under the court's scrutiny. The one would look at the evidence of the company in that respect. And the onus is on, as Macpherson says, for the company to demonstrate that there is a bona fide dispute on substantial grounds.
But then it says, on hearing a petition, the burdens are reversed because being an undisputed creditor is an essential element of the petitioner's case. So what does that mean? Does that mean that when there's a petition to wind up, it is, well, I mean, I suppose it's for the petitioner to show that there is no dispute on substantial grounds?
My lord, I think it's assistance to look at this in terms of how the mechanics actually work in the petition process. So, of course, there are certain things the
So,
petitioner
sorry, just
must
a minute.
agree.
What do you understand that sentence to mean?
My lord, I've struggled with that sentence
Yes.
because one would expect, having been previous strong editorial comment, saying something completely the opposite
Yeah.
direction. If there is a change, one would hope for further editorial comment to explain the change.
The last sentence can't be right, can it?
The process I underwent was to look at the footnote and to think, well, is this recent case law? But of course it's not. It's case law that existed at the time of the previous third edition. And my lord, I
Well,
don't,
we may have to tell the learned editor he got it wrong.
but my lord, you have McPherson on this point as well.
Hmm.
And the fact that there was no dispute on this point.
Yeah.
Although there's no point, ground of appeal in
Yes.
relation to, it's not suggested by my learned friend that the judge has incorrectly applied the burden.
Well, we may have to send a copy of our judgment to the Oxford University Press.
Well, what I was going to say, in terms of the mechanics, because there is an element of burden, of course, on the petitioner. The petitioner must demonstrate certain things in the petition. It must set out that there is a debt.
Yes.
If reliance is placed on the statutory demand route, it must show that the statutory demand has been served. And the court is only entitled to deem insolvency if there is a neglect to satisfy the statutory demand without reasonable excuse. So if you're raising a defence, bona fide defence on substantial grounds, you have a reasonable excuse. You can't rely upon, as a petitioner, upon the statutory demand procedure. So there are evidential burdens on the petitioner, which have been met by the petitioner
Yeah.
in terms of pleading what needs to be pleaded.
It's not an evidential burden on the petitioner to show there's no dispute.
My lord, indeed. And if one then moves to the winding up rules in Bermuda, the winding up rules specify that if a company wishes to dispute the petition, the company must file an affidavit within 7 days. So whatever the objection may be, it may be that it's raising a defence on substantial grounds. It may be that it would be saying, for instance, well, don't wind up the company because the company has an asset that could be sold to discharge the debt. Well, this is important to understand throughout this appeal. Because again, we're sort of telescoping this from how the position looked in July 2021. We have a petition being filed on the 19th of September 2019, with nothing heard from the company since the 2nd of August 2019. My learned friend, Mr. Forts, took the court to the letter from Appointing that said very clearly, saying you want to investigate is not a denial of the debt. If you have anything substantive to say, we will give you 3 weeks in which to set that out. So every opportunity was given. There is no response whatsoever to that letter. And my lords, I've already referred to the fact that the majority of these cases of disputed debts are injunction applications. Because if you, as a company, say, we have a genuine dispute, if you try to wind this up, we will injunct you.
But it is the case that the company observed its position, which it was obliged to do because it wasn't in a position without investigation to be able to say precisely what its case was.
Yes, it's effectively reserving that we want to investigate, we have concerns. And for present purposes, we deny the debt, which is different from a robust response saying, no, we deny this debt because of the conspiracy and fraud and etc.
No.
And
But if it were a genuine response, wouldn't you have expected the former, the kind of response that you got, which is we need time to investigate, rather than an immediate denial?
my lord, no, because again, this must be seen in context. Let's go off. I just find my. I think it's worth looking at this correspondence at this stage because my learned friend, Mr. Potts, has said that the issue of the 2nd of August 2019 letter is a gateway to a rehearing. Now, this is an important point in terms of the submissions of the respondent, that the initial exercise by this is by way of a review. There are essentially 2 issues. Issue 1 is that the appellant contends that the judge was wrong in his conclusions on bona fide disputed grounds. And that is grounds 1 and 2 of the notice of appeal. And the core ground, of course, is ground 1. The second issue, which are, I think, on Mr. Potts' submissions of less relevance, and on the respondent's skeleton make-weights, is the exercise of the judge's discretion. And that takes us to the ground 3, which is marine right and the disputed shares, and ground 4, which is the issue of adjournment or stay or appointment of a provisional liquidator for restructuring purposes. And the first issue concerns a review of the judge's evaluation of the evidence that goes to those grounds 1 and 2. And the second issue is a review of the judge's exercise of discretion. And my lord, in order to get to a rehearing, because that's what the appellant desperately wants, he wants the court to look at all this afresh. The court only gets there if first this court concludes that the judge below did make an error of law. And my lords, I think it's worth briefly just touching on the case law here. And if I could take you to bundle H, it's tab 9. This is a case called Fine Country and Okotops Limited. If I take you to the judgment of Lord Justice Lewison, it's on page 119. And paragraph 50. It said the Court of Appeal is not here to retry the case. Our function is to review the judgment and order of the trial judge to see if it is wrong. If the judge has applied the wrong
what page
test,
is this, Mr. White?
apologies, paragraph 50,
Paragraph 50.
page 119.
Yes, thank you.
Under the role of the appeal court, the Court of Appeal is not here to retry the case. Our function is to review the judgment and order of the trial judge to see if it is wrong. If the judge has applied the wrong legal test, then it is our duty to say so. But in many cases, the appellant's complaint is not that the judge has misdirected himself in law, but that he has incorrectly applied the right test. In many of the grounds of appeal, this is the position here. Many of the points which the judge was called upon to decide were essentially value judgment, or what in the current jargon are called multifactorial assessments. An appeal court must be especially cautious about interfering with a trial judge's decisions of this kind. There are many examples of statements to this effect. And there's a reference to Lord Hoffman's statement in Designers Guild and Russell Williams. Secondly, because the decision involves the application of a not altogether precise legal standard, or a combination of features of varying importance. I think that this falls within the class of the case in which an appellate court should not reverse a judge's decision unless he has erred in principle.
What happens if the judge simply fails to consider a point or part of the evidence?
My lord, that can be. Firstly, we're looking at an exercise of discretion. It's not a pure discretion in the sense that what we're looking at is not the generous ambit test, because the judge here is required to make value judgments.
Well, that's not an exercise of discretion at all. Making a value judgment is not an exercise of discretion. The judge has to determine whether it has been shown that there was a bona fide and substantial defence. That was something he had to evaluate on the evidence But that was not that exercise was not the exercise of the discretion.
My lord, I agree. That is my point. I perhaps wasn't expressing it that well. I mean, what we say here is it's not an exercise of discretion where you just look at the generous ambit test.
Right.
The judge is evaluating evidence.
Yes.
He's looking at all the relevant facts and he's making a value judgment.
What happens if he doesn't address some of the evidence?
Well, my lord, I think what's prominently put forward by my learned friend, I will address this in detail, is what is the position of Mr. Lye's evidence? Because on this appeal, Mr. Lye's evidence in lie 2 is absolutely central to the appellate's case.
But are we in just as good a position as the judge wants to look at that evidence, which wasn't tested by cross-examination, and evaluate it in the same way as the judge might?
My lord, if you are satisfied that the Chief Justice made an error of law in the way he treated the evidence of lie 2, if you're satisfied of that, then that can be a vitiating factor, and it can open the door to a rehearing by this court. But my lord, in my submission, we're nowhere near that yet. I will explain exactly why in some detail. But to give you the taster of that, and why again this is such a peculiar and rather desperate appeal by the appellate, is when we consider Mr. Lye's evidence, it's the world turned upside down. Because Mr. Lye's evidence, specifically lie 2, was utterly peripheral to the hearing below. It was utterly peripheral to my learned friend's submissions and that of Mr. Robinson, the famed dragon. And it's been put front and center on this appeal. And my lord, I'll take you to the transcript in due course. And you can see exactly how my learned friend, Mr. Potts, treated this evidence.
Well, that gives rise to a difficulty. One possible view that we might take is that Mr. Lye's evidence was actually central to the resolution of the question. You're about to show us that it was only peripherally referred to. Where are we then if, in fact, we take the view that any judge looking at it would realize that it was central, whereas it had been dealt with peripherally in argument?
My lord, it's my learned friend Mr. Potts took us to the symmetric test, talks about building blocks. And there was the judgment of Lord Justice Mayles.
Yes.
And in terms of that case, it's a case that it's cited as practice in the head, because it is guidance to judges, particularly trial judges, dealing with findings of fact, and that's made explicit within the judgment. This is not a case where we're dealing with findings of fact. So one shouldn't place over-reliance on that case. But the point here, if one looks at what Lord Justice Mayles suggests, you first need to identify the issue. And the issue here is there a defence bona fide raised on substantial grounds? And that is accepted in the grounds of appeal by the appellant, but then turned on its head in submission. My learned friend's submissions are really that there was a finding of malafide by the judge, which forms no part of the ruling. The application of the second part of the building blocks from Lord Justice Mayles is the judge needs to identify the principal evidence that's relevant to the dispute.
Yes.
Now here we have the evidence of the company in the form of Mr. Zhang. So we have the first and second affirmations of Mr. Zhang. We have the writ in Hong Kong as filed in October 2019. And then we have the statement of claim, so significantly adapted in February 2020. That's the company's evidence. And as I'll show you in due course, that is the evidence that Mr. Potts relied upon. You then have the evidence of Mr. Lye. Mr. Lye is not giving evidence for the company. He's giving evidence for famed dragon. And you may ask, well, what's the relevance of that? Doesn't it all go into the pot? Don't we look at the totality of the evidence? But the evidence of the company on this dispute, bearing in mind it was due to be heard in February 2020, was the evidence of Mr. Zhang. It filed Zhang 1. The court had given directions for the petitioner to respond to that. That's Mr. Zhu's first affirmation. The company then asked for leave to respond on 2 issues in Mr. Zhu's first affirmation. The first issue was they wanted to comment on the Grand Treasure contracts. The second issue, they wanted to update the court on the Hong Kong proceedings as things stood in January 2020. And the court granted permission for what the company had asked for. And then the matter was due to be heard on the 21st of February 2020. And my lords, I'm going to digress just for a moment. I think it's important to understand what happens at that stage. Because Zhang 2, rather than being limited to these 2 extra areas for which the court had given permission, was a 74 paragraph, 41 page magnum opus, backed by hundreds of pages of further evidence, mostly in untranslated Chinese. And the petitioner applied to have that affidavit, certainly to the extent it went beyond the court's permission, to be struck out. A few days before the hearing on the 21st of February 2020, there was effectively a document dump from the appellant. They suddenly provided uncertified translations of their exhibited documents. And what happens on the day of the hearing, bearing in mind we have trial bundles, we have exchange of skeletons, the matter is due to be heard across 1.5 days on the 21st of February, is the judge agrees to strike out the offending paragraphs from Zhang 2 and adjourns the petition in order for the petitioner to consider this document dump of evidence. And my lord, the Chief Justice used a very vivid phrase in application. He said this was a cynical abuse of process by the company, which must not and shall not happen again. And directions were given for the matter to be brought swiftly back before the court in April 2020. COVID intervenes. My lord, so it's important to look at what...
I didn't hear your comment. That didn't happen, I see.
My lord, no, of course, COVID from March 2020, and unfortunately the effect on the Bermuda court lasted for some time.
But there were then, in due course, any number of further affirmations filed. So
Yes,
was there an order permitting that? And I would say,
permission was asked for a affirmation to be filed by Fame Dragon, Docile Bride.
By who?
Fame Dragon
Yes.
and Docile Bride. They had instructed separate attorneys. They had been previously represented, as I understand, by Conyers. And Mr. Lai's evidence is then filed late in March 2020, and a time summons is filed on behalf of Fame Dragon. And that time summons is opposed by the petitioner on the basis that Mr. Lai appears to be reintroducing by the back door what the judge had struck out the front door of court on the 21st of February. In essence, he goes back and attempts to put a gloss over the flow of funds on. And unfortunately, that application wasn't heard until the hearing in July 2021, because that is when the matter first.
at which point, the second, third, fourth, fifth, sixth, seventh affirmations of Zhao were permitted in.
My lord, most of those were procedural. For instance, there's one in support of opposing the time summons. There's an affirmation in support
So
of
when you say there was a time summons, an application for what?
an extension of time for Lai 2.
Oh, I see.
Certainly.
There's no dispute that Mr. Lai's affirmations were properly before the court.
My lord, unfortunately, it's not recorded in the order. The judge did grant the time summons. So it's not suggested, I don't suggest, I wouldn't suggest, that evidence wasn't properly before the court.
The fifth affirmation of Zhao was substantial.
So can I just understand this? Mr. Lai produces evidence in March 2020 you said it was asserted that he was introducing what had been struck out, but presumably that application was either never made or rejected. It was said by whom to whom?
My lords, I apologise. I'm trying to cover quite a bit of ground quickly.
Well, I know that's the problem. If you do it too quickly, I can't follow the sequence.
I do apologise. What was struck out were paragraphs from Mr. Zhang's second
Yes.
affirmation,
I've got that.
because they go beyond the scope
Yeah.
of the permission. A large chunk of what gets struck out of Zhang too is he attempts a regloss, as I would call it, of the flow of funds. And the reason for this is he's confronted with a problem. He set forward an argument, quite a restrictive argument, in his first affirmation, based on the commodity contracts in April 2017. That has been upended by the reply evidence from the petitioner, which has set out the significance of the Grand Treasure contract. Without permission, Mr. Zhang attempts to have a second bite of the cherry. That is struck out. We then, rather surprisingly, have this very long affirmation from Mr. Lai. Bearing in mind, Mr. Lai had filed an affirmation in October 2019, not dealing with any of these matters, attempting to deal with the flow of funds. So it was objected to by the petitioner on the basis that he was trying to reintroduce struck out evidence.
Objected to who, before whom, and when?
My lord, it's set out in the
And with what consequence?
Yes, and with what consequence?
my lords, at Bundle C tab 28, there is an affidavit of Kyle Masters. He is an attorney for Harry Olsen, and they were the attorneys for Fame Dragon and Docile Bright. And my lords, this is the application for the time size. It's the supporting affidavit.
What's the reference again for?
It's at tab 28, Bundle C.
Right. So there are some more time.
Yes, just say we're going through the sequence. Tab 31, we have the second affirmation of Zubin. That's, as I say, a procedural affirmation. It just exhibits the consent to act of the intended, at that point, provisional liquidators from BDO Financial. Tab 32, we have the third affirmation of Mr. Zubin. And if one looks at paragraph 4, he says, I make this affirmation in response to the second affirmation of Zhang Kui. The court had given permission on the 21st of February when adjourning the petition proceedings for a reply affidavit. And that, so it's an affidavit with permission, tab 32. At tab 33, fourth affirmation of Zubin is filed in response to the time summons from Kerry Olsen. And objecting to the admission of that document. At tab 34, we have the fifth affirmation of Zubin.
Well, as I said, it's very important to do with a lot of factual matters.
It does, but with the court's permission. So there was a provision for Fame Dragon and Docile Bright to file evidence. They did so, albeit late. And there was a provision in that order for a response to be filed by the petitioner. So tab 34 is with the permission of the court. The sixth affirmation of Mr. Zubing at tab 35 is a procedural affidavit. This deals with a change in the provisional liquidators. The Chief Justice had indicated in February 2020 that at least one of the provisional liquidators would need to be Bermuda-based. And as my lords will be aware, there's now a change in the winding up rules in Bermuda, which require that to be the case. So there was a change, there was a pivot, as it were, to PricewaterhouseCoopers. So that's procedural affidavit. And then we have the seventh affirmation of Zubing, which was served in unsworn form. There was difficulty getting affidavits sworn in China. On the 2nd of July 2021, that's a short updating affidavit, which deals with, we can see from paragraph 9, the deterioration in Titan's financial position since the last occasion the matter was in court. My lords, whilst we're here, paragraph 10, it refers to the annual results for 2020. These are the results for the 6 months ended 30th of June 2020. And it says Titan has recorded net current liabilities of 934 million. 10.2, Titan's cash equivalent is only 1.65 million Hong Kong dollars, that is, of which the majority is in Chinese money and subject to foreign exchange control regulations. And 10.3, Titan's cash equivalent has marked a decrease of 1.8 million, down from 3.46 million as at the end of 2019. So there is a fall in the amount of cash. Despite the fact that there have been placing agreements, Titan has raised 8 million Hong Kong dollars during the winding up proceedings. Paragraph 12, we have the insolvency of Titan. There's a reference to the annual report from 15th of May 2020.
Why did you not, by this stage, amend the petition to rely on the insolvency?
My lord, that I suppose with hindsight that may have been a possibility. I mean, the sheer oldness about this, and your lordships will note what's being exhibited here and referenced by Mr. Zhu is not evidence from him. He is exhibiting and referring to either publications of the company, so primarily what they publish on the Hong Kong Stock Exchange, and also documents created by them, so their annual reports and interim results. This is why it's hard to understand when my learned friend says, well, we didn't have a chance to respond to this. Well, these are your documents. Sino has no special knowledge of Titan's financial state. It relies on what it publicizes. And for the same reason,
it's relying on them for a purpose which is not perhaps as strong as an amended petition would have provided.
My lord, yes, but I mean, to this day, it's not accepted by the appellant that Titan's insolvent. And it's quite an extraordinary position, bearing in mind where we come to.
I'm getting a little lost. You told us that there was a time summons for the filing of Mr. Lai's affidavit. You said that that was objected to, and the objection was found tab 34. What happened?
My lord, the Chief Justice considered the time summons.
Yes.
And of course, there was a lot of water under the bridge by that stage.
Yes.
And the time summons, this issue was arising in before April 2020. And we then had the hearing in July 2021.
Yes.
So the judge took the pragmatic view that he was going to allow the time summons and gave permission for Mr. Lai's evidence to come into the evidence before the court.
Right.
And my lord,
So Mr. Lai's evidence was allowed, despite objection, was allowed to be before the court. So the fascinating history of how it came there is interesting, but in one sense irrelevant. It was part of the evidence which the learned judge was bound to consider.
My lord, I mentioned this in passing, because I'm bringing it up to date on the chronology. I was responding to my Lord President's questions in that regard. There was an important point of dispute. But to travel back to this.
Wait a minute. Wait a minute. You say there was an important point of dispute. What was the important point of dispute?
The important point of dispute was that it appeared Mr. Lye was trying to reintroduce strike-out evidence.
Right.
Now, the significance attributed by my learned friends.
Wait a moment. If the learned judge, the Chief Justice, allowed that evidence in, he must have allowed it in on the basis that it should be part of the evidence, notwithstanding the allegation that he repeated what, if it did, what had been struck out in Mr. Zhang's affidavit.
My lord, yes, because there's a distinction. This isn't the company's evidence.
I know.
Had the company attempted to do this, had Mr. Lye put on his hat as a director of Titan and said, well, this is a further affidavit on behalf of Titan, no doubt it would have suffered the same fate as the offending paragraphs in Zhang 2. But this was evidence filed on behalf of Fame
But
Dragon.
it doesn't cease to be evidence because it was filed on behalf of Fame Dragon.
My lord, no. But if one is considering the onus is on the company to demonstrate its defence,
Yes.
and the court paid close attention to what the company's case actually was.
But you're not suggesting that it should not pay attention to what was in the Fame Dragon evidence, right?
My lord, no, he did pay attention to it. He confirmed he confirmed he'd read
You
it.
confirmed you read it, yes.
And he
It makes, I think, 3 references to it in the judgment.
there are 3 references to it in the judgment, as noted in my learned friend's skeleton.
But which don't deal with the central point that Mr. Lang was making.
My lord, I think at this stage, if I perhaps give me just a moment to
Yes, of course.
myself.
I'm sorry, I'm trying to stop asking questions.
I did say earlier, this was every appearance of the world turned upside down in terms of how this evidence is being treated. And my lord, the Titan's point of appeal on this, it's I won't take you there, but it's paragraph, it's ground 2.1.2 of the notice of appeal. In fact, it may be worth looking at that briefly. If we go to bundle A, tab 2. It said, this is their complaint. The Chief Justice erred in summarily rejecting the evidence contained in line 2 without any adequate explanation for the purposes of determining whether a bona fide dispute on substantial grounds exists over the petition dead. In the absence of cross-examination of Mr. Lye or any other directors of the company, in circumstances where Mr. Lye is a reputable professional, and the court accepted and relied upon other aspects of Mr. Lye's evidence. Now, that ground of appeal makes an assumption that there has been a rejection, or there needed to be a rejection, of Mr. Lye's evidence in order for the judgment to come to the conclusions that it did. I've already made the point, my lords, that the Lie 2 was admitted into evidence in time summons. It was read by the judge, it's referred to in the judgment. But where this ground gives a misleading impression is that it suggests that Mr. Lye gave evidence, factual evidence, on oath in relation to the bona fides of the dispute. And that is simply not the case.
Where is that said?
My lord,
Mr. Lye gave factual evidence on it. We just referred to that.
well, in my submission, the ground we just looked at gives the impression, it talks about the evidence being rejected. And that does seem to give the impression that Mr. Lai was giving factual evidence on
I
a
know that must be the case.
But wait a minute, when you say he didn't give factual evidence, I don't quite understand what you mean. He adduced and put into various tabulated forms a series of documents containing a multiplicity of contracts and a multiplicity of payments and receipts under bank documents. Isn't that factual evidence?
That is factual evidence, but he is not giving direct factual evidence in respect
Well,
to
he's
what
producing.
He's not a witness as to the
He's
events.
giving it in written form as opposed to oral form subject to cross-examination.
And the complaint is the antithesis of what you're saying, which is that he was not cross-examined, yet the evidence was rejected.
My point is this: he's not the witness of fact.
Why
In the
not?
sense that he is not speaking to what happened in April 2017. He wasn't a director
Well, no, but okay.
in April
So
2017.
what? If a witness says, I have searched in the documents of the company, and I attach 127 documents which establish something beyond doubt, and be it assumed that they do establish something beyond doubt, are you saying that one's not entitled to take into account of that?
One can take it into account, but it changes how one might see that evidence.
Why?
Because if you have evidence, the best evidence, of course, will be from a direct witness. And I hadn't thought this controversial.
You can file an affidavit which is evidence of the matters to which the affidavit speaks.
My lord, yes, I hadn't thought this was controversial because Mr. Potts himself said that Mr. Lai was not a direct witness. He was
But it depends
providing.
what you mean by not a direct witness. What these phrases are slightly elastic. Mr. Lai, on one view, produced the best evidence possible for the relevant transactions, namely the documents by which they were effected, than which there could be no better evidence.
Yes. The distinction I'm drawing here is between, and what I mean by direct evidence, is a witness who directly sees something and then gives evidence.
Yes.
We have, of course, another type of evidence, which is opinion evidence,
Yes.
which is I have looked at these documents and I am giving you my opinion. And it's the second category into which Mr. Lai's evidence clearly falls.
I don't think he purports to give opinion evidence. What he purports to do is list the facts which are elicited from the documents.
He explains what the documents reveal.
It could be said to analyze the documents, but that's actually rather helpful because he tabulates them all in a form whereby you can see the sequence, and he tabulates the cash flows which emanate from the documents. It is true that he says it can be inferred from this that there was a fraudulent scheme, which I'm not quite sure that's a matter of opinion. Nothing he suggests flows from the documents that he's produced.
Well, my lords, in my submission, he is giving an opinion.
Okay, so of course, assuming he was giving an opinion, since the judge had presented to him all of the documents on the basis of which Mr. Lai said that the inference could be drawn, it must have been incumbent on the judge to decide whether he agreed that the inference could or might be drawn, wasn't it?
My lord, he was entitled to treat the evidence for what it was, which is a mix of speculation and opinion.
Well, wait a minute.
By Mr.
Wait a minute. It's not speculation. The production of all the basic documents has got nothing to do with speculation. Tabulating them in an intelligible form has got nothing to do with speculation. Saying that the inference that can be drawn from those documents as helpfully tabulated is X is not speculation, but an inference that he said could be drawn. It is not possible to ignore that evidence upon the footing that it constitutes speculation or opinion. Is it?
My Lord, I'm not suggesting for a moment the evidence should be ignored. My submission is it wasn't ignored.
Well, where did the judge, right, you say it wasn't ignored, where in his judgment did the judge deal with the points that and the basic point that Mr. Lai was making in his second affirmation or affidavit, that if you looked at the totality of the transactions, it showed that there appears to be a fraudulent scheme for the purpose of procuring the money paid by Sino derived from Titan. Where does he deal with that?
My Lord, I think this takes us down the route of the appellant trying to isolate parts of the evidence, because it is clear in my submission the judge did have heed to Mr. Lai's evidence.
Well,
Confirmed it read. The criticism here by the appellant is, look, there should have been a great big chunk of this judgment dealing with Mr. Lai's evidence. It's not there, so it must have been rejected. But my lords, I'm going to actually refer you to, if you can look at bundle G, this is the skeleton arguments.
Yes. Your submissions?
And yes, this is the respondent's submission.
Right.
And this starts from paragraph 52.
Paragraph 26.
Sorry, 52.
52.
Somewhere.
So we've already covered part of this. So referring to the ground of appeal, what said is Chief Justice erred in rejecting the evidence contained in Lie 2. And it said that this couldn't be done without cross-examination of Mr. Lai. And then paragraph 53, it gives the impression that Mr. Lai gave factual evidence on oath in relation to the issue of bona fides of the petition debt. In reality, however, Mr. Lai could not and did not give any direct factual evidence in relation to the bona fides of the petition debt. That issue relates to events which occurred in April 2017.
Rather than, in other words, you use the words on oath in 53, should we not have used them also in 54?
He's speaking to the evidence as the bona fides, 54.
So Mr. Lai was not appointed as a director of the company until 26th of July 2018, over 1 year later. And then 55, it ought to go without saying a witness statement should be confined to facts of which the witness can give evidence. It's not, for example, the function of a witness statement to provide a commentary on documents nor to engage in matters of argument, expressions of opinion, or submissions about the issues. And we come to the nub of it in 56, that the fund flow section of IT breaches all of those guidelines. It sets out various anomalies and red flags, as he sees them, in his view, said to have been identified in Mr. Lai's review of the trading contracts, which in his view suggests they were possibly false.
Isn't this revisiting the question of whether the evidence was properly before the court? I thought you have accepted that it was properly before the court.
No, my lord, this is a completely different point.
But wait a moment.
Not
Just a moment. What happened in relation to various anomalies and red flags is that Mr. Lai referred to the characteristics of a whole lot of contracts. The characteristics to which he referred in relation to those contracts appeared, for looking at them, they appeared from the terms of those contracts. What Mr. Lai helpfully did was to work out a purely mathematical exercise what the profit was to be derived from those contracts, which the court could have done for itself, much more helpful if somebody else had done it, and worked out what that would constitute for a year. I can't see how any of that was inadmissible. Was it?
My lord, I think we seem to be across purposes.
Yes, we are.
I'm not suggesting this evidence is inadmissible.
No.
I'm suggesting exactly the opposite. It was admissible. It was considered by the court. What I'm going to
Well, wait a minute. What you say, 50, is that the evidence breached a whole lot of guidelines. So you're not saying it's inadmissible, but you say in
No,
effect,
I'm saying it's
you shouldn't be much
speculation
effective
opinion,
because it breached all the guidelines.
and would be weighted accordingly. And that reflects how it was treated.
But it didn't breach any of the guidelines in this respect. Well, it seems to me that it is perfectly possible for an accomplished and experienced liquidator, particularly if he's an accountant, to assemble all the relevant documentation to say it shows the following transactions, to say the documentation shows the following characteristics, and a number of those characteristics are rather dodgy because they have, for instance, a minuscule profit return. Now, whether or not that is something which might be thought to be dodgy, the court can make its mind up. But I cannot see that Mr. Lai can properly be criticised for what he put in his statement, affirmation. Methinks.
My lord, again, I think we may be across purpose. It's not a matter of criticising Mr. Lai, but actually, what is this evidence dressed up to be? It's, as Mr. Potts conceded, it's not direct factual evidence. He is putting forward what he says is his forensic examination. It's effectively quasi-expert evidence being put forward by Mr. Lai in circumstances where this is not independent expert evidence and there's no permission from the court for expert evidence. Well, where I'm going to is this, is the judge, and this is paragraph 58, the judge was entitled to see his evidence as providing opinion on what may or may not have happened, which is the effect of the evidence in light.
I have a problem with the characterization of opinion, because what he is doing is drawing together the factual elements that appear from the contracts. He's not expressing an opinion on them.
And the capacity as presence as a liquidator.
He's, Mr. Lai is doing, in fact, if one had simply bundled all the contracts, Mr. Lai is doing what counsel would do.
Yeah.
Counsel would take court
Yeah,
through
it's rather better than
show
I mean, this could all have come from counsel, but it would be much more convincing to come from somebody who understands it. Counsel sometimes do, not always.
My lord, yes, but what's being said is that the judge has rejected this evidence. He didn't need to, in the sense that this isn't evidence of the facts, as witnessed by Mr. Lai. We were looking at a simple factual dispute. There is no probative value in cross-examining Mr. Lai on his.
Well, is there any probative value in Mr. Lai's evidence?
My lord, it's limited. It's extremely limited.
Why is it extremely limited?
It's peripheral.
Why is it peripheral?
Because the task before the court is to consider the bona fides of the company's defence.
Yes.
Now, key to looking at that is how the company has put that defence. It's not for a third party to come along and say, well, the company hasn't done a very good job, and therefore I'm going to try and fill in the gaps. The judge was correct in looking at the company.
That can't be right. Let us assume that the company says, I think this whole thing is a dodgy and fraudulent arrangement for the following reasons, and it actually puts it rather badly. But somebody who is entitled to participate in the hearing produces a much better exposition, which reveals with much greater clarity why what was said by the company was in fact correct. You're not seriously suggesting, are you, that that evidence should be treated as peripheral, simply because it comes from somebody who, although not the company, is entitled to appear upon the hearing of the petition?
And supports the company's position.
My lord, it was treated as peripheral.
Well, that's wrong, isn't it?
Well, if we take up on the left and look at the transcript, so this is tab 63.
Right.
And if we could go to page 244.
Credit. Water. Yes, F63.
F63, page 244.
Yep.
And if we look at the numbers on the left, go to 19.
Which numbers are we using?
Sorry, the numbers on the left, they go from 1 to 23. These are the time, effectively, timings, I think, on the transcript.
We start at line 19.
Yeah, so line 19. And these are, I know the friend, Mr. Potts' submissions.
Just a moment.
And he's coming to the end. of it.
Just a moment.
So Mr. Potts has spent quite a bit of time at this point going through flow of funds, etc. And at line 19, he's rounded up. He says, now, those are really the points on the evidence that I just wanted to cover. Pausing there for a moment, if we looked over the preceding pages, Mr. Potts had taken the jug through Zhang 1, Zhang 2, the Hong Kong writ, and the Hong Kong statement of claim. That's the evidence that is covered. And reading on, but I can ask your lordship, when you have a moment to read carefully through our written skeleton, in terms of all the points we have made, and also obviously to have regard to our affirmation evidence, as well as its denies evidence. Although the latter affidavits were filed on behalf of or through Mr. Robinson. So I'll let him take you through that evidence. Now, my lord, this is the only mention of lie 2 by Mr. Potts.
What about Mr. Robinson?
Well, Mr. Robinson, to complete this view, is at 355.
$355.
355, yes.
Are these yours?
I think this reference may be wrong, if I can just check it. Just.
I mean, I haven't done it, but if you go to 319, Mr. Robinson is talking about the line out there.
My lord, sorry, it wasn't 355, it's 335.
Thank you.
There's an error in my note.
No, easily done.
So Mr. Robinson's submissions, it's line 10, if we're looking on the left. And it said, I don't intend, my lord, I don't think it would be helpful to go over Mr. Lie's evidence with regard to the flow of funds. Mr. Potts has dealt with that on the company's evidence. Mr. Lie, of course, does go over that. My learned friend, Mr. White, objects to that. But I simply invite my lord to consider the whole of Mr. Lie's evidence in support of both Fame Dragon as the majority contributory and also Docile Bright, we say, as the majority creditor. So, my lord's a curiosity. Evidence that is central on the appeal occupies reams of my learned friend's written submissions and hours of the time before the court. That is how it's dealt with. It's dealt with as peripheral evidence. And my lord, it's dealt with as peripheral evidence for the reasons that I've given. That it's evidence that's come later, not from the company, but from Fame Dragon. There's an analysis by Mr. Lorry, but really it is just a further analysis being offered to the analysis already before the court from Mr. Zhang and from Mr. Zhu. And my lord, the dispute as it's
Now,
framed.
where are we if we come to the conclusion that the evidence was A, not peripheral, B, wholly admissible, C, of substantial import, and D, that the judge failed to give it the attention that it deserves or to analyse it at all?
My lords, if you decide that this is appropriate for a rehearing, then you can consider the matter afresh.
Oh.
Now, I would make submissions against Mr. Lie's evidence being treated in that way. But before we get there, this court would have to identify an error of law corresponding to my learned friend's ground of
The error of law is not considering it. Simple as that. Doesn't deal with it at all in the judgment. You're perfectly entitled to say the council could have made a good deal more of it below than they did, and a good deal more of it as they have now. But it's plain that the judge was invited to consider it. And in those circumstances, to consider it, he should have done.
My lord, in my submission, this is an illegitimate change of case on appeal, because there is a difficulty with Mr. Zhang's evidence coming from the judgment. Of course, the judge found that Mr. Zhang had been misleading in his evidence.
That's another point.
It's no surprise that reliance upon Mr. Zhang has been abandoned. And now the life raft of Mr. Lai's evidence is being grasped at. Now, of course, it's an unfair criticism of the judge to say we didn't fully consider all these points, which we actually never raised with you. We never addressed you on these points.
Well, wait a minute.
We never put the evidence.
Wait. I don't wish to be unfair to the judge at all. It's perhaps understandable why the judge adopted the approach he has in the light of the feeble way in which the matter of Mr. Lai's evidence appears to have been urged on him below. I quite accept that. And he also wasn't impressed by Mr. Zhang, who he thought had not been honest with the court. But that can't, I'm afraid, detract from the fact that Mr. Lai too's evidence was in fact relevant and does not appear to have been considered, and if it wasn't considered, is not addressed in the judgment.
Well, my lord, with the symmetric case, Lord Justice Mayles' guidance, the judge must consider what is the principal evidence. And the principal evidence is not purely to be dictated, of course, by the advocates. The judge is perfectly entitled to say, just because something isn't referred to by an advocate, that it may be relevant. But the principal evidence here was to consider whether the company had demonstrated it had a bona fide dispute on substantial grounds. And integral to that is looking at how the company put its case. And the judge did correctly identify the principal evidence, which is Zhang 1 and Zhang 2, the Hong Kong pleadings, and the counter evidence of Mr. Zhu. There's no failure in the building block process in my submission, which would give rise to such a finding. Now,
So Mr. Lai might just as well not have given evidence at all.
my lord, this is a type of hearing, not a trial. It's probably most analogous to a summary judgment.
Yes.
And my lord, there is, in terms of what a judge is supposed to do in such circumstances, my lord, there's an authority I would take you to on this point. You may recognize the phrase used, and it's quite a dramatic phrase in the sense that a judge he's not filling in a pre-flight checklist. And to explain that reference,
He's not merely a what?
a pre-flight checklist.
Oh, yes.
I'll explain this in context. I know we're coming up towards the break, perhaps. If we can look at this authority, if you'll just give me just a moment.
No.
Which tab?
Well, this is the it's the case of Re F in bundle H, which appears at tab 22.
22. This is James Mullen, is it?
Yes, Sir James Mumby. And the relevant section is paragraph 22. Under discussion. And it says, like any judgment,
What tab did you say?
22.
it's
Tab
22,
22, thank you.
paragraph 22. Which is like any judgment. The judgment of the deputy judge has to be read as a whole, having regard to its context and structure. The task facing a judge is not to pass an examination or to prepare a detailed legal or factual analysis, of all the evidence and submissions he has heard. Essentially, the judicial task is twofold: to enable the parties to understand why they've won or lost, and to provide sufficient detail and analysis to enable an appellate court to decide whether or not the judgment is sustainable. The judge need not slavishly restate the facts, the arguments, or the law. To adopt the striking metaphor from Mr. Justice Mostyn in SP versus EB and KP, there is no need for the judge to incant mechanically passages from the authorities, the evidence or the submissions, as if he were a pilot going through the pre-flight checklist.
Mhm.
My Lord, my submission off the back of that is this: it's quite clear that the judge did have regard to Mr. Ly's evidence, because he told the parties that. He said he'd read it, and he found it sufficiently relevant to grant permission under the time summons and to override the petitioner's objections. He also mentions it on two or three, I think 3 occasions within the judgment. But if it's not the principal evidence on this point, which it wasn't treated by the parties, I don't say that's just an artificial point, because it was treated by the parties for a reason, because it was regarded as peripheral. Now, does that amount to an error of law in these circumstances? Well, in submission, no. If there was no indication at all that the judge had read and taken into account the evidence, then at that point may have more weight, but that is not the case here. And really, this is almost like a point of appeal going to a question of weight. And a question of weight, whether sufficient weight is given to a particular factor, is not a proper ground for appeal. Unless the appellate.
But no weight was given.
My Lord, I suspect I may know better on this point with you, but my submission, so it's clear, is that the judge clearly did attach weight to it.
Well,
because it's part of the evidence.
Where do we find that? Where do we find in the judgment that he gave any weight to anything that Mr. Lye said?
My Lord, it is by implication in his recital of the evidence he took into account. He sets out all the various affidavits right towards the beginning of his judgment. I can't put it any more than that. My Lord, I can't point to a section where he says on this issue I took into account Mr. Lye's evidence, because that's not there. I know that's my Lord's point, which is why I deal with it in this way, to say it wasn't the principal evidence being considered.
And I have problems with this class distinction between evidence. Evidence is evidence. It might be wrong.
My Lord, I don't think I can do any better on that particular point.
Thank you. Right, where do you go from here?
My Lord, the other point on Mr. Lye's evidence, and this is quite apart from the submissions already made, is where did it take the company's case forward? Because first of all, I think it's helpful at this point to revisit the company's own evidence.
Yes.
On the flow of funds issue. So if we could go to, this is bundle C, and if we could go to the first affirmation of Mr. Zhang, and page 191.
Thank you.
And my learned friend had read through some of this, I think from paragraph 33 onwards yesterday. We come to the nub of it. There's a heading C2.
Yes.
And it says potential route for fund flow from Titan Group to Sino Child. My Lord, I'd ask you to note potential route, because this is the highest that Mr. Zhang puts it. Now, of course, today Mr. Potts makes a very robust submission about this being a fraudulent scheme, etc. but in the evidence, Mr. Zhang, it's a potential route. And he says, in short, the evidence suggests that under a series of transactions, funds were diverted from Titan Group to Max Joy, from Max Joy to Uniloyal, and finally from Uniloyal to Sino, as seen in the chart below. And the chart is, we've looked at this before, it's got various iterations elsewhere in the evidence. But we have the key allegation tied into these commodity contracts between the 18th and the 20th of April 2017. These are back-to-back contracts. And we can see the upstream purchaser contracts being set out in the diagram. And then paragraph 35, it said, we've seen that shortly before the convertible bond purchase, the total sum of approximately 78 million apparently flowed out of Titan Group to Max Joy Uniloyal before the same amount was used to fund provide liquidity for the CB purchase, i.e. with the same sum of $78 million travelling back into Titan Group. And that is the purpose of the arrows, to show the flow of funds.
Yeah.
And then we've got, he gives further comment, paragraphs 37, 38, 40, 41. He goes into more details about these contracts. Now, what is not said here, of course, are the downstream buyer contracts involving Grand Treasure.
Do we know that he knew of them then?
My lord, he must have known, because, as my learned friend points out in the skeleton argument, in one of his footnotes, there is one of the Grand Treasure contracts exhibited in the exhibit to Mr. Zhang's evidence. And that is the contract between Grand Treasure and HTO1, Petrochemicals. There are none of the other supporting documents, the various bills and notices, etc., provided. But there is one contract. And it is an oddity because, as far as I can see, it is the only, in 1,000 pages of exhibit, it is the only exhibit which has no corresponding text.
Which can you just give me the reference to that? I remember it, but
Well, I was afraid you were going to say
Yes.
that. I don't have the
give it to
reference
me
at
at 2
the
o'clock.
tip of my fingers. We can find that reference
Yes.
for you now.
Yes, please.
Provided. So clearly it was known to, or should have been known to Mr. Zhang, because that contract is exhibited.
Yeah.
I mean, it was suggested by my learned friend that this was some inadvertent error, and maybe it had been left out. But that was a submission advanced without support of evidence. Mr. Zhang, when he was given permission to address these issues in his reply affidavit, and this is tab 26, this is Zhang 2. I'll really direct your lordship's attention to a paragraph, so we're trying to prove a negative. He doesn't give the explanation that Mr. Watts has set forward. The comments he makes in relation to the Grand Treasure contracts is he says they are irrelevant.
Where does he do that?
Paragraph 43, page 273. It says, however, Sino-Charm's objection is in fact a distraction and is no answer to Titan's key allegation that the funds for the convertible bond purchase came from the Titan Group itself. Indeed, Sino-Charm has conveniently avoided the issue of what it has done with the funds it received from the Titan Group.
Yes. Well, the Chief Justice was understandably unimpressed by the failure to refer to the contract with Grand Treasure in the first place. You say the explanation for not doing so is pretty lame. But of course, what we do get is the important fact from the evidence of Mr. Lai that the sale to Grand Treasurer was not for any payment anytime soon, but for payment months later.
My lord, that was a matter canvassed in submissions before the learned Chief Justice. It was no secret, it wasn't a fact overlooked. The payments made under the Grand Treasurer contracts, there are various dates. There's payments in June, November, and December of 2017.
Right.
My lord, can I just give you this reference before I drop this bundle? The Grand Treasurer Petrochemicals contract
Yes.
appears in bundle D1, tab 43, at page 1306.
Thank you. Would that be a convenient moment to adjourn?
My lord, yes, I think it was just before 1 o'clock.
Very good. We will resume at 2.
Cameras and mics and
They say till 2, yeah.
Oh, yeah. Line first and 17. In French, I just couldn't find that reference. It's classic. So that's 17. That's good fine. I think we're reading it's still my point. So much of it. Yeah, like that.
About an hour and a half.
Yes.
The minutes that seem to have been logged out from the Zoom, so I need the person you're going to come up and
You seem to be back now. No, it says respondent is connecting to audio.
Yes,
They are connected now.
Right, we have you now.
My Lord, yes. If we can go to the second affirmation of Mr. Lai,
Yes.
Article C, tab 29, and paragraph 37.
yes,
Paragraph 37, page 313.
yes,
And my Lord, in this paragraph, Mr. Lai says finally to take a step back into 2017, when the convertible bonds were issued, Titan just finished its restructuring a few months earlier. And according to annual report of 2016, the Titan issued in April 2017, it had approximately Hong Kong $258 million in cash and approximately Hong Kong 601 million of current assets. And he makes this point. He says Titan had no immediate need to raise funds, and in fact, the majority of the Hong Kong 78 million raised from the issuance of the convertible bond was applied to acquire the suspicious shareholdings, etc. And he goes on to make an argument which isn't pursued on appeal by the company, which is that the money invested by the company was spent to the benefit of Tang and Dr. Wei Bing. Now that is contrasted with the Chief Justice's ruling that it was used for the purpose stated by the board, and that was a purpose of expansion, and that's accepted in the concession at paragraph 61 of my learned friend's skeleton argument. But that's by the by, because the point being made here, Mr. Lai in his evidence is starting with the proposition that Titan had no need of money. It was cash rich in 2017. Why would it need money for expansion? And he does so, he makes this point by relying upon current assets and current cash. Now, of course, as an accountant, he would know that would be simply one half of the balance sheet. The true story, you need to look at the other half and current liability.
the statement that he does make, what I would have thought needed to be backed up by evidence. And so far as I'm aware, Pacific Ocean might be a thriving business that was worth the expenditure of 49 million Hong Kong dollars on. But he characterizes it as a suspicious shareholding and says it brought no obvious benefit to Titan's just revived business. Does he give reasons for those statements?
My Lord, that actually wasn't the point I was intending to make. For the appeal purposes, Chief Justice in his ruling, I think it's useful to look at this point briefly in bundle A. And I don't have the reference to hand, so I'm doing this slightly out of order, so if I can just have. Yes, it's looking at the ruling, it's paragraph 51. And I'm going to paraphrase this for time purposes. There's an announcement following the board of directors of the company held on 12th of April 2017. The board considered the issue of the bond to Sino, and in addition to Mr. Wei Bing and Mr. Tang, the board of directors were attended by 5 other directors, 2 additional executive directors, Mr. Hongwei, Mr. Liming, and also by 3 additional independent non-executive directors, namely Ms. Singh, Mr. Lawfei Lawrence, and Dr. Han Jun. It should be noted that no allegation of breach of any fiduciary or other duty is made by the company in these proceedings or in Hong Kong. against these 5 directors of the company in relation to this matter. The other 5 directors are not parties to the Hong Kong proceedings. Paragraph 52, after consideration of the terms of the proposal, the minutes of the board meeting record that the directors note the proceeds will be used for shipbuilding and ship repair businesses, including future investment needs or other purposes in Singapore. After discussion, all directors unanimously agreed to issue convertible bonds and considered the terms of the subscription agreement, and the terms of the convertible bonds are general commercial terms, etc. Paragraph 53 is not disputed that Sino has fulfilled all of its obligations under the subscription agreement. And then there is a reference below to the 2018 annual report, which deals with the actual use of fund proceeds. And briefly over the page, again, I'll paraphrase. About 20 million was used for the payroll of the group, rental and utility charges. 4.7 million was used for capital injection to Sino Shipyard, and 49 million was used for capital injection to Pacific Ocean, a company which focuses on investment in shipbuilding industry. And so, paragraph 54, in the circumstances, it's clear that the purpose for which the bond was issued was considered and was unanimously approved by the board of directors of the company. And it also appears the actual funds proceeds.
Hold it right there, because what is said in lie is that the company's awash with cash. It doesn't need the convertible bond to be able to discharge $30 million worth of payroll.
Yes, and he's wrong in that, and that's the point I was coming to.
Oh, I see.
I will come to that. Bond was largely in accordance with the stated purpose. Further, in any event, the allegation the bond was issued with the primary purpose of entrenching control by Mr. Wei Ling and Mr. Chang over the company seems to be at odds with the present application to wind up the company. And that, my learned friend in his skeleton argument says, for the purposes of these proceedings, the appellant takes no issue with the findings in paragraph 54, certainly to the end of the word stated purpose.
Well, I guess I'm slightly puzzled about this, because he does say that it takes no issue with that. But what is said in paragraph 53 is that 78 million was used for 20 million for payroll, 4 million for injection into some stock company, and then 49 million was used for capital injection into Pacific Ocean Marine. And it's in relation to the 49 million that Mr. Lai's evidence, paragraph 38, relates, because he recalls 38 times injected 49 million of the funds that were subscribed into Pacific Ocean. And he says the Pacific Ocean utilised those funds to subscribe to a convertible bond issued by China Ocean Industry.
My lord, yes, I'm conscious of the time. The short answer to this is that is not a point taken on appeal.
What do you say?
Indeed, expressly, there is a concession, as it were, within paragraph 61 of the appellate skeleton.
Well, that's my
They
point.
take no issue with
I
these
looked at
findings.
paragraph 61 of the American skeleton. Appellate skeleton should appear to say that the finding in 53 was not disputed. But 53 doesn't deal with what happened to the 49 million to which 53 refers, which was injected into the Pacific Ocean.
Paragraph 61 of the appellant's skeleton refers to the extent the judge addressed the issue's conclusion of 49 to 57 of the judgment. He held that the issue of the bond had been approved by the entire board of Titan, which included a substantial number of non-conspirators, and that the funds raised by the board were used for the purposes approved by the board, that's paragraph 49 of the judgment, and largely in accordance with the stated purposes. And that's paragraph 54 of the judgment. And that's why, my lord, in our reply skeleton, we say, and I don't want to tread too quickly on different points, that is a fatal concession within the context of improper purpose, because a company is raising funds on the Hong Kong Stock Exchange, it's getting paid money It's taking money, and it's using the money for its stated purpose.
Well, yes, but the stated purpose was to pay 49 million into Pacific Ocean. It's accepted that 49 million was paid into Pacific Ocean, but that, or could be said to beg the question as to what happened to the money when it got into Pacific Ocean. It doesn't.
My lord, this isn't the point being taken on appeal.
Well, is that right? Tell me.
It's not in the grounds of appeal, it's not in my learned friend's account.
Right. Is any reliance in the appeal placed on the point made by Mr. Lai in paragraph 38 of his second affidavit?
The way it's framed in our scope argument, my lord, is that for the purpose of this appeal, we don't take issue with the judge's comments in those paragraphs, but we fully reserve the position so far as the Hong Kong litigation is concerned. But from our point of view, it completely misses the point. Because
sorry, what completely misses the point?
both the judge's observations in those paragraphs, but also my own reliance on it. Because we submitted the Hong Kong litigation as part of the dispute that the exercise of issuing the bond was for an improper purpose. It does not matter that bond monies were used for the purposes which at the time the then board said they were planning to use bond monies for. It can still be an improper purpose no matter the law. And that's our case. So in the Hong Kong litigation, if it ever gets to that point, we will of course be challenging whether in fact the monies were used for the purpose of the 49 million going to that company, and then the matters that are raised in Mr. Lai chapter in paragraph 38 will be at issue again in the Hong Kong litigation. But for the purposes of this appeal, we're really trying to streamline it and not waste too much time on relevant points. We're not particularly taking issue with those paragraphs of the judge's findings because they are, we say, irrelevant to the court's analysis of the issue before it. So using the language of concession, unfortunately, is not that helpful. Because we're not conceding anything. We're just not wasting the court's time dealing with it for the purpose of it.
So, my lords, returning to my point on this is really the issue we're looking at is what is the weight that could be attached to Mr. Lai's evidence.
Right.
And there is a difficulty, first of all, in his starting proposition. His starting proposition is the company has plenty of cash. It didn't need to raise additional funds. That is indicative of his thinking. Clear indication. He thought, at this point, there's no other explanation other than that there is something, use the broad phrase, something a little bit dodgy going on. And my lord, he does so by looking at one half of the balance sheet. So he's considering current assets and current cash.
Yes.
But he ignores the other side of the balance sheet, which if we go to bundle D1, tab 43, which is the annual report from 2016, page 772.
So, yes. Yes.
772. So we had the figure of just over 600 million in current liability, current assets. If we go down the page, we have total current liabilities, third from the bottom, of 527 million. And then on page 817, same document. We have the total of the current the heading is, it's a little bit faint on my copy, but it's interest-bearing bank and other loan payables within 1 year, in 2 to 5 years, inclusive after 5 years. We can see the total there of the interest-bearing bank and other loans is $390 million. So straight away, if one adds the other half of the balance sheet, one can see that when one looks at current liabilities against current assets, the position is quite removed from the initial impression created by Mr. Lai. But we can do better than that because we have the annual report for 2017, which is same bundle but at page 950.
On 950?
915.
91.
What year is that? What year's report is that?
My lord, this is the 2017 interim accounts. Well, sorry for the pause. I just want to check something. Yes, at 915, we've got the group ad. This is under A. Cash and bank balances of 83.4 million. And it says what the balances were comprised of underneath. So the actual amount of cash at the end of that year was relatively little. So the idea that the company was desperate for cash, wasn't desperate for cash, is misleading. And of course, the court did pay attention to the contemporaneous documents, which included.
Do we know where Mr. Lai gets his numbers from?
My lord, I presume his current assets comes from the document I took to you first. That was page 772. That's the 2016 report.
I'm sorry, I was not. I'm just trying to compare those numbers with the ones that Mr. Lai gives in paragraph 37.
Yes. My lord, if you go back to 772, where current liabilities are identified, if you go further up, you'll see current assets. Current assets is in the left-hand column. There's a figure of 600 million.
Sorry.
Middle column.
Of which 257 million is cash.
Yes. But offset against that, of course, is 527 million.
But the answer to my
It's right there.
is there.
So the total cash would only be about 73 million Hong Kong dollars.
Right.
No.
And there's also I took you to the current loans because there's also $390 million worth of loans to be serviced. Now, the contemporaneous documents, so the internal corporate governance documents of the company, support the need that it was appropriate for the convertible bond to be raised, and that the money was going to be for a stated purpose, which is for expansion of business, and that money was largely spent for that purpose. There is some further indicia of financial distress to Titan, in that some 20 million of that was spent on basic payroll, etc., of the company, and broad heading of keeping the lights on. But my lords, without the loan from Sino, and since it's accepted the money, the purposes of this appeal, it's accepted that the money was spent on Titan Group purposes and expansion, it's difficult to see how that could have been achieved without this loan. Now, we touched on the existence of Mr. Lifey Lawrence.
You say without a loan?
Sorry, without loaning further money through the convertible bonds.
Oh, true.
Yes.
Without borrowing.
Yes. And the significance here, of course, you don't have a completely new board coming on for the purposes of 2018, 2019. You have a transition of board members, but there's one consistent figure, and it's a robust board in 2017. You've got 4 executive directors, 2 in addition to Mr. Tang and Dr. Wei Bei, who no finger of suspicion is pointed at. There are 4 non-executive directors who no finger of suspicion is pointed at, and who aren't parties to the Hong Kong proceedings, and there's no suggestion of breach of duty against them. And indeed, in Mr. Lawrence's case, he was a member of the board that approved the CB in 2017, a member of the board that approves those minutes saying it's been used for the stated purpose. And he's also on the board of the company when the statutory demand was received. And my learned friend took that letter the 2nd of August, where it was said, well, the board doesn't know anything about this because it's a new board. That wasn't right. And he's also on the board during the currency, at least the beginning of these proceedings from 2019 into 2020. I don't know if he sits on the board still. Certainly the annual reports include him until 2020. So that is where Mr. Lai starts his evidence.
Right.
And then we go on to the flow of facts. And apologies for this, I know we've looked at this a lot. The argument that we raise is this, that Mr. Lai starts with his conclusion. He starts on the assumption that money has been siphoned from Titan Group to Sino. And in the 3 stages of the fund, he works backwards and he draws every necessary inference in order to justify that conclusion. And this is done so in a context where, self-admittedly, he's not looking at all the transactions undertaken by the company. He's focusing on particular transactions. And there was some $920 million, so almost $1 billion of commodity transactions in 2017. And he assumes connections between parties and he assumes payments. And if we look at page 321, and we have the first stage of the fund.
When you say he assumes payments, he produces bank statements which show payments.
Well, he's got evidence to produce it. Where he doesn't have evidence, he makes an inference.
Well, I know, but you said he assumes connections and payments.
I was making that as an overall broad submission.
Well, you may have been, but whenever I have seen reference to a payment, it appears to be supported by a document.
Well, my lord, we're just coming on to fund flow 1,
Okay.
which includes a payment where there is no document.
Right.
So if we look at fund flow 1, we start with the Petro, so we've got step 1,
Yeah.
step A, B, H. And in relation to that step 1, he identifies the payments regarding Max Joy. In step 2, he says the documents obtained from Max Joy transferred these sums to Unioil immediately. Now, he makes no mention at that stage of any trading contracts between them. He goes on in step A3 to deal with the supposed contracts between Unioil and Sino. And he says the total price stipulated in 2 contracts was close to 17. And he says it can be inferred from the timing of the contracts. The payments occurred before Sino Chom's payment, the subscription price for the convertible bonds. Because it's absolutely vital for his argument that it be inferred that they take place beforehand. If they don't, the argument runs into the wall. So there's an important inference there. But also, in regard to this payment, purported payment, between Uniloyal and Sino Chom, again, the fact of payment is being inferred.
Sorry, say that again more,
In relation to
say that again more slowly and more loudly.
Sorry, my lord.
Say that again more slowly and more loudly.
My lord, yes. So he makes 2 inferences in step A3.
Yeah.
The first is clearly stated. He said it can be inferred from the timing of the contracts that the payments occurred before Sino Chom's payment of the subscription price for the convertible bonds.
Yeah.
Now, he doesn't know that. That's why he's inferred. Self-evident. But it's an important inference for his argument, because if it occurs after, if the sequence is out, then the argument that he presents runs into the wall.
Right.
But there's also a second inference, which is that the payment took place at all. And my Lord President, you said, well, that there is evidence to deal with payments. Well, not this payment. And it's actually fundamental to the argument.
Just a moment, are you saying that there's no documentation to show A3 in that diagram?
Yes, it's assumed that there is payment between Uniloyal and Sino.
Well, as I understand it, tell me if I've misunderstood it. the assumed stroke inferred payment A3 is to take the contracts which are referred to at item J below and produce the price payable under those contracts, which is, I assume, 6,695,400 for one US dollars and 25,968,896 for the other. In other words, he looked at the contracts, worked out the contract price as derived from the contracts, and in that sense inferred that the contracts were paid for in accordance with their terms and that it was on a date prior to the 26th of April. Is that how he's approached that?
There are two inferences. One is in respect of time, which you explain.
Yes.
The other is inherent within, or implicit, I should say, within paragraph J. He infers that there has been an actual payment made. Now, it's one thing to say, well, if contracts work out as they're supposed to, the payment would be made. But of course, that is a substantial leap. I mean, a lot of the contractual disputes seen before the courts involve non-payment.
Did Sino Chom produce any evidence as to whether or not A, there was a contract, and B, whether it was performed?
No, Sino Chom's position is it provided the money itself. It's an investment company.
I know that.
Yes.
That isn't an answer to my question. Did Sino Chom produce any evidence that the contract was performed and paid for?
Or the contrary?
My lord, it couldn't, because it denies any existence. It denies any participation in this contract. Their position is, we didn't enter into this contract with Uniloyal. That's it's all clear within the Hong Kong proceedings.
Yes, within the Hong Kong proceedings it is. But there are 2 trading contracts which were produced by Mr. Lai. Did Sino Chom produce any evidence to say that these contracts were false?
My lord, Sino Chom would be unable to produce any evidence that you'd be asking to try and prove an negative.
No.
In the Hong Kong proceedings, that may well be an issue.
But wait a minute. Look at D1, tab 43, page 1357.
That's one of the contracts. Yes.
There is
Sorry, my lord, what's the reference?
1357.
Great.
At 1357, 57, there is a sale and purchase contract of the 18th of April 2017. And this is the first of the ones referred to by Mr. Lai, whose number is Unit 2017-0418A. It's a contract which appears to me to be on Sino Charm's contract form. And see page 1358. It appears to have been agreed and accepted for and on behalf of Sino Charm International by Mr. Chen. Was there any evidence before the learned judge that this is just fake?
My lords, my lord, there wasn't any evidence.
The answer to my question is no.
That there is no money received from Titan. It is their own money put forward.
I follow that.
And then it's made crystal clear within the Hong Kong defence. And my lord, the way the parties dealt with it was both in terms of evidence and the pleadings. What sauce for the goose is sauce for the gander. If the company can make points on its pleadings, then it's perfectly acceptable for Sino's Charm to say, we've made this dispute clear. And it was treated below as being a dispute. My lord, no counsel is suggesting to you that evidence of document examination would be produced or should have been produced in these proceedings.
Okay, well, let's
It may be an issue later in
well, I
life.
can follow that it's a dispute, but at the very least, there was prima facie evidence, contrary to what apparently Sino Charm says in the Hong Kong proceedings, that there were in fact two contracts dated the 18th of April 2017, which, if performed, would involve the payment of a purchase price of approximately 78 million Hong Kong dollars. That's the position, is it not?
My lord, my point was actually just a short one, that there's no evidence of payment, and therefore he infers it. Now,
I know.
that's on the
I
basis
know, but on the whole, people perform contracts.
my lord, that is an inference.
Yes. But if somebody showed me a contract between two reputable persons, I would assume that they performed it. Or at least that it was possible that they performed it.
Well, I mean, it's a huge assumption to make. I mean, what of Mr. Potts'
It is.
key
It's a
points?
natural inference.
One of Mr. Potts' key points on these commodity contracts is to say, well, look, they're not being paid on time. There's payments coming later. I mean, Grand Treasure is an example of that. There are payments in June, there's payments in November, there's payments in December.
Oh, yes, but the payments came later. They came, not that they never came.
And the later was in accordance with the terms of the contract.
Well, a contract where, of course, doesn't come later is Topwin, which is
Well, I know.
as a bad debt. My lord, I think that point would carry more weight if it was the only inference being drawn. At the start of perhaps the foothills climbing the mountain in terms of the inferences. We're only dealing at this stage with that particular fund flow of line two.
Whether there's an arguable case anyway.
My lord, if we continue on to the second fund flow, and there's key inferences drawn here, they're identified at
Sorry, just a minute. Put this from the way. Sorry, where are you getting to now? We're getting to the next round of
my lord, yes, it's page 323,
323.
paragraph 48.
Right.
So here we have 5 payments of 2.9 million. I'll paraphrase, from Petrochemicals, Max Loyal, Max Joyton, Uni Loyal, Topwin, Grand Treasure, and Brilliance Glory. And it said it can be inferred there was a payment of 2.9 million from Uni Loyal to Topwin on or before the 29th of July. So in order to make his argument work, he's applying what he would consider a necessary inference. But it's an inference nonetheless. We're building upon two existing inferences. We've got a third here. And then below in 49, it said, this is a bottom sentence, therefore it can be inferred that approximately 0.64 million was retained or absorbed by Uniloyal and or Top Win, or siphoned off elsewhere by them. And this reflects the speculative nature of his evidence. He needs to make this inference. He's not really bothered whether it's absorbed by Uniloyal or Top Win, or just siphoned off elsewhere. It's an awkwardness in his calculations, because somewhere it needs to be fitted in. This is a way to fit it in. And he draws the inferences in order to do so.
Right.
My lords, if we then go the page to page 324. Sorry, if I could just pause for a moment.
Yes.
324, so this is the third circle. And we get to D at the bottom. And it said, in the circumstances, it can be inferred that Top Win received a sum of approximately 90.3 million from China Oceans between the 22nd and 29th of December, either directly or through third parties, unidentified third parties. And again, this is necessary to make his argument work. There's no evidence of that payment. It's an inference. And this is perhaps the most sketchy inference, perhaps of all. And it's just simply adding either directly or through third parties. My submission is wholly inadequate. And it's also based on the supposition that China Oceans is under the control of Hang Wei Bing, consortium of the two, however the appellant wishes to term it. China Oceans isn't a name that's particularly figured in this case. And he makes the assumption that China Oceans is part of this conspiracy as well. So, my lord, it may be possible, if one were simply drawing one inference, it may be possible to say, well, everything else ties together. That is a permissible inference to make. But if one builds this stack of inferences, and they affect each stage of three fund flows, then, my lord, there is considerable concern about this evidence. And this reflects my earlier submission. I don't mean this in a derogatory way to Mr. Lai, but if you start with the conclusion that money's been siphoned off, and you've got patchy information, and he concedes himself he doesn't have all of it shown, it is going to be only possible through inferences to come to the conclusions that he does. Allied to that, he starts with completely the wrong proposition, because in his mind he thinks Titan doesn't need this money because it's cash rich, not actually correct on a proper analysis of the accounts. Then, my lord, this is into the realms of speculation. Just because it looks superficially impressive. We have these charts, we have multicolored lines, we have all the appearance of sophistication. But at the end of the day, this is a very convoluted piece of evidence involving 14 steps to get from the beginning to the end and multiple inferences. It quite simply doesn't stand up. And it's not how the company started its case. The company started its case in saying, well, that the money had been siphoned off in April 2017. Money had gone through the circular flow set out by Mr. Zhang and in the Hong Kong writ and ended up in Sino. That didn't work. When you look at the actual commodity contracts, the back-to-back, you can't discount grand treasure payments. There's a profit of almost $1 billion Hong Kong dollars.
Stop. When you say it didn't work, it depends what you mean. Go back to page 321. Titan Group in two forms paid Max Joy on the 20th of April. Max Joy paid Uniloyal on the 20th and the 21st of April, Unioil had contracts with Sino, which, if performed, would have involved a similar payment, which it is suggested was before the 26th of April, and that is said to be such that Sino was able to pay Titan. When you say it doesn't work, in fact, Titan Group produced the money for payment to itself by buying from Matt Joy, who bought from Unioil, who bought from Sino. There was an arrangement with a contract with Grand Treasurer, who were counterparties, but that wasn't to be performed until December. But the provision of funds to Unioil and hence to Sino from Titan Group did work.
How so, my lord?
Because Titan Group paid Matt Joy paid Unioil, it is inferred, paid Sino, and Sino paid Titan. That is how it worked.
My lord, that does hit the nail on the head, because the final stage involves the two inferences.
Yes,
which I just identified.
but when you say it doesn't work, you appear to refer to Grand Treasurer, which at this stage has got nothing to do with it.
I meant it, if the inferences aren't made, it doesn't work.
If they're not made.
If they're not made,
Yes, if the inference is
that must be the
well, I
case.
follow that. Yes, that I had understood.
Sorry, I was going back to the company's evidence in relation to Grand Treasurer.
Essentially, the inference being drawn here is that the contracts were performed in terms.
But I'm adding to that.
But sorry, when you say you were going back to the company's evidence in relation to Grand Treasurer, what are you meaning?
Because we see this very complicated 14-step, 3-fund flow structure in Mr. Lye's evidence. We don't see that in Mr. Zhang's evidence. And my lord, before the lunch break, you might remember I took you to the fund flow diagram in Zhang's law and the heading potential flow of funds.
Yeah.
And that is replicated. That argument is replicated in the Hong Kong writ filed in October 2019.
Yes.
And this is why Mr. Zhu says in his first affirmation, well, if you're looking at those commodity contracts, they're back-to-back contracts. You've got to look at the upstream and the downstream contracts.
That I follow.
Yes. There's a fundamental
There are
shift.
two different questions. The first question is whether what happened in April could have enabled, well, had the effect that Titan Group, by this indirect process, enabled Sino to subscribe. That was undoubtedly possible because Titan made the payment to Max Joy made the payment to Unioil. It could be inferred that Unioil paid Sino. That, in that sense, works. That's point number one. Point number two is that you can't look at the Titan Group purchase to Matt Joy without taking into effect the countervailing sale by
Grand Treasurer.
Grand Treasurer. True, but if you do that, you have also to note that the contract with Grand Treasurer did not fall to be performed until the middle or late 2017. There are 3 or 4 separate points.
My lord, yes, but you're equally entitled to note the fundamental change in the case between how this dispute was raised and how it would have been decided in February 2020 and what has occurred after the disclosure of the Grand Treasurer contracts. Because Titan's tried to change its case, it's had those sections of Zhang 2 struck out. And Mr. Lye has been called upon as a non-company witness to try and remedy defects by setting out a very elaborate analysis of the evidence, which is reliant upon 14 different steps. And we've identified 8 different inferences. inferences at each stage.
Mhm.
And that must be considered in the round.
Mhm.
And he does so because he starts. This is what we describe as confirmation bias in the respondent's skeleton. If you start out with a particular destination, you can make the evidence work through the application of inferences. And my lord, it's also fundamental that he got the wrong starting point.
Right.
He assumed that Titan Group didn't need any money. And my lord, there is another explanation for this, because it's only by the reason Titan needs to say, well, you should analyze a wider body of commodity trading contracts, is because their original one, just on the April contracts, didn't work. So they say, well, take into account trading for the year. There is a bad debt from Topwin. Okay, that bad debt is a number of millions more, but the 78 million subdivides into it. And therefore, there is this leakage of money from Titan. But my learned friend doesn't even attempt to deal, nor does Mr. Lai deal with what's happened with these excess millions. My learned friend says in his written submissions, they've leaked away. Where's the analysis of that? Where is this other 6.5 odd million gone? There's no cogent, there's no attempt to explain that. It's wholly inadequate to say it was just washed away somehow.
So which 6.5 million are you talking about?
The total Topwin debt was, I think, just over 84 million Hong Kong dollars. So there's about a $6 million difference.
Yes.
There might be a few 100,000 in there as well, but that's the broad figures. My lord, there is a perfectly plausible explanation, rather than it being this incredibly elaborate conspiracy, which again rests on assumption that all these parties are under common ownership, when really there's no evidence, certainly no cogent evidence, that Sino is controlled by Tang or Beijing. It's really, I mean, it's the cart before the horse, because it said, well, the money is siphoned at Sino, so it must be under the control of Tang Wei. That doesn't work. You can't infer one from the other. That is far too great a leap. And the simple explanation, this is a bad debt from Topwin. And why on earth would some macabre conspiracy be devised by Tang Wei Bing in relation to the Topwin debt? Because when this occurs in end of 2017, they are still executive directors on the board. In fact, they're executive directors on the board well into 2018. Point made by my learned friend's skeleton below at G3637. I mean, Tang is there till October, I think back end of October 2018. So why on earth would the music be stopping with the Topwin debt in 2017? It makes absolutely no sense. And my lord, you can't just view this in isolation, because there's the argument on flow of funds, there's the argument on improper purpose. We know this has been board approved, including by using the tendacious language of the appellate, non-conspirators, including one of their directors who was steering the ship during the early stages of litigation and oddly gave no evidence. And then we have, in terms of improper purpose, well, there is no improper purpose, because the company wanted to expand, the company has spent the money on expansion, and how on earth would this entrench Tang Wei Bing's control anyway? As the learned judge noted in his ruling, how is a collective winding up proceeding in any way consistent with entrenching control? The only way it could work to entrench control is if you assume that Titan Group is going to default on the convertible bond. And why on earth would you do that? It's come out of restructuring in 2016. It's looking at a process of expansion. There's no reason to assume in those circumstances that it would fail. And my learned friend puts forward this explanation. He says, well, Famed Dragon, he makes a point of the date Famed Dragon goes into liquidation, and says, well, Tang and Wei Bing are taking advantage. Well, my lord, that is a classic example of a submission being advised without evidence, because that's not what's said. in the evidence below. The only evidence is the simple fact when Fame Dragon went into liquidation. So really, when we look at Mr. Lie's evidence, he may be trying to do his best, but it is speculative, it is opinion, based on his analysis of the documents with those conclusions in mind.
Right.
My lord, there are concerns. I mean, if we're looking at this with our perhaps rehearing hat on for the moment, there are concerns about Mr. Lie's objectivity. And those are clear from, if I can ask you to look at bundle A.
Yes.
And if I could ask you to turn to the cost ruling, which appears at tab 6. My lords, I don't know if you've had a chance to read this yet.
Well, I've skimmed read it.
Okay. Not relevant for our present purposes, but there was an argument about whether Zhang should be ordered to pay the costs of the petitioner. And as part of the evidence behind that, we get paragraph 26. It said that, third, it is undisputed that Mr. Zhang funded the litigation on behalf of the company in opposition to the petition filed by the petitioner. This funding was advanced by Mr. Zhang in circumstances where the company itself was unable to finance the litigation. In the judgment, the court found at paragraph 60 there is persuasive evidence that the court was in fact insolvent and was likely to be insolvent at the time of the presentation of the petition. Paragraph 27, subsequent to the presentation of the petition, Mr. Zhang advanced various monies to the company at a 0% interest rate. He accepts those advances were used to fund the present litigation. On behalf of the company, Mr. Zhang says the advances were also used for other corporate purposes, such as paying salaries for employees. Paragraph 28, at the bottom of the page, Mr. Zhang advanced during the period 13th November to 9th of Feb 2021, 20 separate amounts totaling Hong Kong 10.3 million. And 29, fourth, even though the company was facing a winding up petition based upon deemed insolvency due to failure to honour the statutory demand, the company continued to raise money from third parties. The exhibit to the affidavit of Mr. John McSweeney shows two convertible bonds issued by the company dated 13th of March 2020 and 23rd of March 2020 in the amount of 4 million Hong Kong dollars each, so 8 million in total. The exhibit to the affidavit of Mr. John McSweeney also shows the proceeds of 8 million raised by these convertible bonds were used on 26th of March 2020 to repay Mr. Zhang the amount of 5.4 million and thus substantially retire the company's indebtedness to Mr. Zhang. And paragraph 31, but it's over on page 67. It was said by the company at the hearing that the court should pay regard to the fact that Mr. Lai had supported the petition. It said the court is not persuaded by the fact that Mr. Lai, director of RSM Corporate Advisory Hong Kong, also supported opposition to the petition. Makes any material difference. The court did not find that Mr. Lai's evidence in this regard was entirely objective. And then there's further information in the footnote. And my lord, Mr. Lai has been put forward as a very experienced accountant. Part of the evidence he gave in Lai 2 was to suggest that in his view, it would be possible, if a winding up order wasn't made, for the company to pay the petition debt. This would either be raising further money or by some form of financial restructuring. Mr. Lai, rather incredibly, despite the company's own announcements in 2021 that it was balance sheet insolvent, had no working capital for the next 12 months, and was unable to raise money, advanced that as a notion. At the same time, he's failed to disclose that Titan, not Titan Group, Titan the company, is being kept alive purely by small loans provided by Mr. Zhang. Not only that, on Mr. Lye's watch, despite the presentation of the winding up petition, the company has got into further debt. They wanted to raise 10 million, they could only raise 8. And that money has been used as a preference to pay Mr. Zhang, to make sure he's as not as out of pocket as he can be. And my lord, this does colour the objectivity of Mr. Lye. He's got into the trenches here with the company. And he's lost his objectivity. And my lord, there is another matter. We started the proceedings yesterday. I mean, it's said in the, if I can ask you to turn to bundle line.
Sure, I follow that. I mean, you say that he's produced what you regard as ludicrously a confident suggestion that the company could find some further monies somehow or some form of subscription, and hasn't revealed the company's only been kept alive due to Mr. Zhang. I quite follow that. And you say that the judge didn't find his evidence entirely objective. I'm a little puzzled by what appears in the footnote at page 13, where Mr. Lye gives a legal opinion that the various significant evidence which suggests that the title of the shares did not actually pass from Saturn to DBIL, and unfortunately the title didn't pass from DBIL to Marine Price.
My lord, yes, that's in relation to line 3.
I know that.
Which is a...
But is that a legal opinion? Just let me finish. Is it a legal opinion to say that there's significant evidence which suggests the title didn't pass? That's what the evidence is, that's true.
My lord, the discussion between, I think, Mr. Robinson and the Chief Justice during the hearing was the Chief Justice expressed, I suppose, an initial view that much of line 3 read as if it was a legal submission. And I think that's the point he's referring to within that footnote.
Well, that's right.
Of course, one bit of evidence, you know, if we're looking at his, my learned friend puts this very highly, so there's inherent credibility in Mr. Lye. And it suggests that this is somehow from his status as an accountancy professional.
Yeah.
And of course, my lord, that's just as a trite proposition of law, that must be wrong. There's no inherent credibility in a barrister giving evidence, a solicitor, a doctor, a priest.
Accountants have no inherent credibility.
My lord, that's not my point. But I mean, if one, for instance, we're looking at evidence.
I was only half joking. What is your point?
My lord, one looks at the evidence as it is, as it stands. One doesn't say, well, simply because you're an insolvency, you have credibility.
So if I'm asked to choose between criminal and archbishop, I might start with a preference towards the archbishop.
Perhaps, my lord, perhaps.
But
But
I also would have to look at the evidence objectively.
I mean, a classic example, I mean, there's plenty of reported decisions from public interest winding up petitions in the UK, where it's the Secretary of State for Trade and Industry who brings those petitions.
Yes.
And often they result in contests. And it's not that the Secretary of State's evidence is imbued with any inherent credibility. The court takes the view, we've got to look at the facts of the case, we've got to look at the issues. And that's what needs to be done with Mr. Lye's evidence.
Right.
And my learned friend, it is very notable, both in written submissions and oral submissions, he continually prays in aid. Mr. Lye is an accountancy professional, liquidator appointed by the Hong Kong court. And that, in my submission, is indicative of trying to paper over the problems I've identified in his evidence.
Right.
And all these are reasons why this evidence was peripheral below, because it really doesn't advance matters, because we've got the key battleground outlined by Mr. Zhang. Mr. Zhu's engaged on that. You have Mr. Lye coming relatively late in the day and putting his own analysis. But it's essentially that. And he does it on loads of different issues. If I could take you back to the skeleton arguments in G.
Yes. It is E, is it? No.
My lord, sorry, if I could ask you to look at the appellant skeleton.
G.
Is it?
And My Lord, it's paragraph 29. One of the things that we've argued in our skeleton in support of this argument that Mr. Lye is essentially giving an opinion evidence is aptly illustrated by paragraph 29 of the appellant's skeleton. And what my learned friend does in paragraph 29 is pick what he thinks are the choice bits of Mr. Lye's evidence. We start with 5 under paragraph 29. In light of my role in the company, I am in a position to confirm the company's findings of the wrongdoing by Wei Bing and Tang as outlined in Zhang 1. Now that's his first affirmation. So he's simply giving the permission, his opinion. But yes, I've looked at what the company's view is and I agree. That's his opinion. Below that, from line 2, he says, having had sight of the evidence found in these proceedings, the liquidators and docile Brighton liquidators have reached the conclusion there is at a minimum a substantial dispute as to the validity of the debt claimed by Sino. Well, that's neither here nor there. Again, opinion. 6, Fame Dragon
You say it's neither here nor there, but that's presumably something that the liquidators were bound to address their mind to.
in performance of their duties as liquidators.
And if they had reached the conclusion that there was no substantial dispute, they would then have to say something, or at least be silent. And if they reached the conclusion there was a substantial dispute, they'd have to say that.
My Lord, yes, but to be precise, my submission is this. As far as the court considering whether there is a bona fide dispute on substantial grounds,
No.
and it's one of these things, you're entitled to express your opinion, but it doesn't carry any evidential heft behind it. It's simply his opinion. And same example, or similar example, 6 below. You know, the liquidators take the view, 7, this is to do with restructuring. If the debt stated in the petition is determined to be due and payable, tied with the support and cooperation of Fame Dragon, those Bright and other creditors would be capable of raising sufficient capital to pay the debt. Now, that's quite an incredible assertion because Fame Dragon is insolvent. The parent of Fame Dragon is insolvent. Docile Bright is insolvent. The parent of Docile Bright itself is insolvent. That's GZE Hong Kong, which is in turn owned by GZE, which is insolvent. So we've got a cabal of insolvent companies, a company surviving. And bearing in mind, Mr. Lye is giving Lye 2 in March 2020. So this coincides with the point in time during which Titan is trying to desperately raise funds on the Hong Kong Stock Exchange and failing to hit its target in order to repay Mr. Zhang and to keep the lights on because they can't pay salaries, they can't fund the litigation unless they have that extra money. And he's suggesting seriously, as an accountant with 18 years experience, that is going to be viable. My Lord, if we then look at, I can actually look at bundle I.
Yes.
And we have, it's tab apologies, it's the JPL's first report, which appears behind tab 64.
Yes. This is a document attached to your skeleton submission.
It is. It's in the record appeal at where it appears in bundle I.
Okay.
This, of course, wasn't a document before the Chief Justice. It's been created, obviously, post the winding up order. It has clear relevance. It was introduced primarily in relation to a ground of appeal, which seems to have been abandoned, which is that the Chief Justice gave too much consideration to the consolidated accounts of the group rather than the accounts of Titan. But we have on 1.2, on the left-hand side on page 4, JPLs have requested but not yet received a statement of affairs from the directors of the company. As such, the latest financial information available to the JPLs is the unaudited 2020 consolidated accounts, management accounts, which were obtained from the company's books and records. And over on page 6, there's some expansion on that. Page 3rd paragraph from the top. The JPLs have also reached out to the directors of the company and requested they provide the JPLs with a statement of affairs, which of course is a statutory obligation to comply with that request. We provided the directors with 14 days notice to provide the SOA, the deadline of the 31st of August 2021. However, the JPLs confirmed that to date there's been only one formal response from the directors of the company. My learned friend suggested there had been something provided, I think Mr. Zhang, yesterday. But our understanding is that to this date, there has been no statement of affairs provided.
Sorry to rise and interrupt, but that's just simply wrong on my instructions. And you need to look at the date of this report to creditors. This document dates back to the 4th of October 2021. It's a report not to the court, but to creditors. It's qualified at page 2 with all sorts of caveats. It's actually wrong in the deadline that it purported to impose on directors, because under the Companies Act, you have a 28-day deadline, not a 14-day deadline. And I'm instructed that Mr. Zhang provided an affirmed statement of affairs to the liquidators in November 2021. November. And I mean, for what it's worth, I have a copy of it with the notarial stamp. But it's not only wrong to make the submission as it's been made just now, but in the written submission to my learned friend, it was suggested that there had been a final deadline imposed by the JPLs, which is simply not correct. So I'm sorry to have interrupted, but it is quite important that the court is not left with a incorrect impression.
My lord, the inquiries were taken overnight, so there seems to be a difference in information being received. My lords, if the court has any concern on that matter, it can direct the JPLs to clarify that point.
Well, if there's a copy that exists of the statement of affairs, and we can be provided with it, the answer will be apparent therefrom.
I've never seen.
I know you've never seen it, but if it can be produced, it obviously exists. It's in Mr. Potts' hand.
I'm afraid I only have one copy, but I can hand to my learned friend to show them. I should point out that it would be provided by the director to the liquidators. It would not ordinarily be provided to the petitioning creditor. Okay. And so the fact that Mr. White has not seen it is really neither here nor there.
No.
Well, I wasn't making a point, I was simply stating a fact.
If it helps, I could also say that my instructions are that although the notarized affirmed copy is dated November, it was the product of actually drafting and communications between the director and the JPLs, because it's an iterative process to reach the point of the affirmed version. So had the JPLs attended court, or had they actually submitted a court report, which is contemporaneous with this hearing, one would hope that they'd actually have updated the court in that respect.
Well, I think we'd like to see a copy in due course, but not immediately.
My lords, whether that was treated by the JPLs as being sufficient or not, I don't know, but I think only the JPLs could confirm that. But the point on the report, it's a report filed with the court. And it's, as one would say, it's the first part of the reports being filed with the court and ahead of the first meeting of creditors. But what it does is set out clearly the condensed consolidated financial position of Titan Group.
Yes.
And that's on pages 8 and 10. Sorry, 8 and 9.
8 and 9.
And we can see there that, cutting to the chase, really, the 31st of December 2019, we have total assets less current liabilities, figure in brackets, of 812 million odd. And then 31st of December 2020, the column on the left, in brackets, 850 million odd, so the indebtedness has increased from December 2019 to December 2020. That's during the currency and proceedings. But when we're looking at the condensed statement of the company, it's over on page 10. And we can see, starting with the right column, 31st December 2019, we have 536 million, just under 537 million in brackets, total deficits. And in 2020, that has increased to over $571 million dollars. So it's balance sheet insolvent both in 2019 and 2020. Now, the Chief Justice had very clear evidence before him of what the situation was in 2020, 2021, because the company was in crisis, and it made numerous announcements to the Hong Kong Stock Exchange. And he had also highly persuasive evidence that it was likely to have been insolvent in December 2019. And the report from the JPLs puts that into context. Even more so, I suppose, if it's actually based on what Mr. Zhang says is the current position of the company. My Lord, just...
Well, it helps on this. You were asked by Justice Bell, why wasn't the petition ever amended to claim actual insolvency? We may find ourselves in a position, I mean, if you're right, and there was no arguable defense to the debt, certainly the order is like, the order for winding up is likely to stand, unless we were persuaded that it should be stayed because of the prospect of some form of resuscitation, which you say is illusory. That's possibility number one. Possibility number two is that we come to the conclusion that the charge was wrong, and that there is in fact a bona fide and reasonable defense along the lines of that which is currently being pursued in the Hong Kong proceedings. We would appear then to be in a position that because the petition only relied upon the debt to which there is a reasonable defense, the winding up should be set aside in circumstances in which it is apparent from the latest information that the company is in fact balance sheet insolvent.
My Lord, in those circumstances, so if the winding up order was set aside,
Yeah.
and the court formed the view that clearly there was actual insolvency in the company, which is supported by overwhelming evidence, then the court could exercise the powers of the Supreme Court to wind up on that basis. And my learned friend, they say, well, technically there would have to be an amendment sought by the petitioner, because at the moment the petition relies upon deemed insolvency. But my Lord, bearing in mind that there seems to be, the overwhelming preponderance of the evidence on insolvency, that would be an application. It'd be difficult to see why it wouldn't be allowed in the circumstances. We're talking hypotheticals. So the court would be able, in my submission, to wind up on that basis.
So we
also,
upon the court, although the petition is not brought upon the basis of insolvency, but on the basis of an indisputable debt, you say to you, the court could nevertheless wind up the company on the grounds that on the evidence that has been produced it is in fact insolvent.
The court has a very broad jurisdiction under section 164 of the Act, so it can adjourn, stay, or dismiss a petition. But if we're in a scenario where essentially the order of the 11th of August is being rolled back, so the winding up order is set aside, I can't see, and this is just engaging with this point on my feet, I can't see why there would be any bar to the Court of Appeal, bearing in mind it can exercise the powers of the Supreme Court as a winding up court to make a winding up order on that basis. Now, I was taking a
There'd be
possible
no-
objection my learned friend might raise.
Just not in response to that, there'd be no petition before the court for winding up on that basis.
My lord, well, the winding up order would be set aside. There would still be a live issue for the court. What happens with the petition?
Yes, but the petition would be based on the disputed debt, found to be so.
My lord, yes, but I think my Lord President's question was angled to, well, there's evidence of actual insolvency. And that is a basis to wind up the company under the Companies Act. Could that be done by this court? I think the clear
Without-
answer is
without
yes,
a petition.
but it may require amendment to the petition.
Oh, I see.
A further possibility, of course, my lord, is that there is another creditor present in court who may wish to substitute in those circumstances. I know not. I don't know what their position would be in the circumstances. But I would say the fallback position of Sino would be, because the court has this jurisdiction to stay or adjourn the petition. And indeed, this is what is being argued for by Mr. Potts in relation to his ground 4. He says proper weight wasn't given to that issue by the judge below. Is the court could set aside the winding up order and stay the petition, because the very least, the appellant says, paragraph 2 of the skeleton argument, the petition has a prima facie case, and that's evident in the documents. We have the convertible bond. There's no dispute the money flowed to Titan. There's no dispute it didn't flow back. It's the argument of the bona fide substantial grounds that intervenes. Actually, I'd put that much higher, because of course, when the court looks at bona fide substantial dispute on the authority in Tarleton Lakes, it is a relatively low threshold, as the judge noted below. And in my submission, there is a very strong case, even in those circumstances, that Sino Charm would be the petitioner. And there would be an issue if the petition was simply dismissed, then the presentation date would be lost. And the court will be no doubt aware of the consequences of that, because it would impede action by any future liquidators and the ability to look at transactions. And in this case, we have 6 transactions post presentation of the petition, including the disposal of 2 direct assets of Titan, Titan Fujuan and Titan Oil Storage, which are void as a matter of immutable law, section 166 of the Companies Act. There would be transactions that couldn't otherwise be set aside by a later liquidator. And my lord, there are authorities cited in aid of that argument within the skeleton argument. My lord, if you go to bundle G, tab 2. Paragraph 34. It said there's good reason for adjourning the petition to await the outcome of ordinary proceedings, including where there is a risk that if the petitioner to establish its debt, the company would be.
This is in your submissions?
My lord, yes, it's tab 2.
Yes, what
Bundle
paragraph?
G, paragraph 31.
31.
31.
Yes, you said, yes, you said 34.
So good reason for adjourning the petition to await the outcome of the ordinary proceedings include whether there is a risk if the petitioner to establish its debt, the company would be unable to pay it. And that would clearly be a risk in this case, bearing in mind the company is insolvent. 2, there is a risk that creditors may be prejudiced by the loss of the commencement date of the petition, e.g. as a result of post-petition disposition. This may affect a number of different statutory claims with the limitation periods for clawback, a link to the date of presentation of the petition, including section 166(1) of the Companies Act, 1981, which automatically renders void any dispositions of property made by the company after the commencement or winding up unless approved by the court. An authority cited under that of Bi-Coastal Corporation Shinwa, where there was a stay pending appeal, decision of the Hong Kong court, and also there is general reference in French. I don't think that is a controversial submission to make, because the court has this general power. It's dealt with under paragraph 23 of my skeleton. It's pursuant to section 164 of the Companies Act. Discretion whether or not to make a winding up order, or hearing a winding up petition, the court may dismiss it or adjourn it unconditionally, or make any interim order, etc. There's also the well-known Bermuda Authority ZOB in the authorities bundle, which deals with the discretion. So, my Lord President, I hope that has addressed the particular question that you were posing. Is there any other aspect to that?
Well, yes and no. I think it might be helpful if we consider the possible results that might arise from this appeal. One possibility is that we dismiss the appeal, in which case the winding up order will take effect and the liquidation will continue. The second possibility is that we allow the appeal upon the footing that there should be the conclusion that the debt, there was a real and substantial defence to the debt. If we allowed the appeal, we could set aside the winding up order. That's one thing we could do. Would that have the effect that the petition was dismissed?
No.
My Lord, no. I think it, certainly my understanding is it simply resets the petition, or setting aside the order. So there's then a question what to do with the petition.
Yes, that's what I thought. So we set aside the winding up order. Then in relation to the petition, there are two possibilities. One is to dismiss it, and the other is to adjourn it pending the Hong Kong proceedings.
My Lord, the court could adjourn or stay. It may be, perhaps there's not too much material difference
Between
between the
those.
two. That may be.
And the third possibility,
submission.
is that we say that the coal company is already balance sheet insolvent and has been for some time, that we should, we might be the result that we allow the appeal insofar as the decision was reached that there was no defence to the debt, but permit you to amend your petition and make no order in relation to the winding up. In other words, the winding up continues upon the footing that the company is hopelessly insolvent. Those seem to be the possibilities.
My Lord, yes.
Any others?
No, I don't
No,
think so.
I don't think so. Thank you.
My Lord, I'm conscious of the time that we need
Well,
to.
don't be too conscious, because although I'm eager for you to make steady progress, there have been certain developments. There seems to be a misunderstanding in the case tomorrow as to whether one of the advocates of the appellants was going to appear in person or by Zoom. And she thought that she was going to appear by Zoom. And we have arranged for tomorrow's case to be stood over until Monday, so that she will be available to be here in person. It may be that this court will be required by the Supreme Court sometime tomorrow to accept guilty plea in a criminal case, but I can't imagine that is something that will take very long. So it is not absolutely essential we are finished by 4:30 today.
My Lord, I'm sorry to stand, but can I just alert the court to the fact that I am scheduled to be in the Grand Court of the Cayman Islands tomorrow, starting at 11 o'clock Bermuda time through to 2 o'clock Bermuda time, with a 3-hour hearing in front of Mr. Justice David Doyle, which is to be conducted by Zoom from Bermuda. So if I could somehow be either given... I'm sorry, I'm in court in the Grand Court of the Cayman Islands by Zoom tomorrow, starting at 11 o'clock Bermuda time for a period of 3 hours. So I personally,
That's a Zoom hearing.
it's a Zoom hearing, which I'm conducting from here. It's another quite substantial case, and it's actually, it would be personally difficult for me to withdraw from that case or secure an adjournment of it, given its importance.
Would Mr. Williams be able to?
If you were happy for me to absent myself for that period of time without taking offence, then that might be one solution. Or we started a bit earlier, and if we started earlier and I could be released in time for that 11 o'clock hearing, that would be convenient. But I would just ask the court to bear that in mind.
The criminal case can be at any time. Yeah.
I could also be available after 2 p.m. hopefully for the afternoon slot.
Well, let's keep going until the normal close of play today, and we'll see what's the most convenient arrangement to fix with the most accurate time estimate as at 4:30. Yes. Right, those are the possibilities.
My lord, yes, there are. I think, given its prominence in the appellant's skeletal appeal, I'll turn to the issue of the Hong Kong proceeding.
Yes.
How they fit in, where they're relevant, and how the judge treated them. So, if we could go back to the judgment, bundle A and paragraph 58. And the first ground of appeal I'm addressing is the complaint that the judge found that the Hong Kong proceedings were commenced in retaliation to the presentation of the winding up petition in Bermuda. And this is, as I say, paragraph 58 of the judgment. And the judge explains that it's plain the Hong Kong proceedings were commenced in retaliation to the presentation of the petition. The petition was presented to the court on the 20th September 2019. Hong Kong proceedings were commenced on the 21st of October 2019, and they weren't served upon the petitioner until about a year later. And the court accepts the claim itself is hedged with caveats and uncertainty. The pleaded claim is stated in body to be subject to discovery, interrogatories, and/or further investigation. And that's paragraph 50 of the general endorsement. Now, my lords, this is a conclusion which is being reached in the context where the judge has looked at the creation correspondence. And to recap, there was the statutory demand in July, the response from Conyers saying they wanted 3 months to investigate, what my client did, on the 2nd of August 2019, and the response from Appleby the 12th of August saying you're not setting out any grounds of dispute. If you've got anything substantial to say it, and we'll hold off for 3 weeks. Now, in the end, the petitioner held off for 5 weeks, and there was never any response to that letter. So the next thing that happens in time is the presentation of the petition on the 19th of September. And then we have the filing of proceedings in Hong Kong on the 21st of October. There's a complete lacunae of any action. In Bermuda, there's no correspondence. There's no further contact at all from the company. As I've already said, there's no injunctive applications and strikeout applications. The company doesn't even comply with the winding up rules to file an affidavit within 7 days if they intend to oppose the petition. They decide to go to Hong Kong, file the writ there, and then 2 days later, they file and serve Zhang Wong in Bermuda. And why the court refers to paragraph 50 of the general endorsement was in reaction to a submission. This, in fact, looks like a rush job.
Looks like
It's done in a hurry,
right.
because it is expressly said to be subject to discovery, interrogatories, and/or further investigation. And the sketchiness of this is reflected in the section from Mr. Zhang's affirmation I took you to, the heading at C2, which is potential route for flow of funds. That's as high as he put it in the company's evidence. So, my lords, in the context of the evidence, this was a perfectly permissible finding for the Chief Justice to make. It's not, as my learned friend suggests, just a matter of time. Petition comes first. The Hong Kong writ is filed second. Therefore, it's retaliatory. That is to take it out of context. And of course, the judgment must be read as a whole and its structure noted.
What is the significance of the fact that it's retaliatory? If I say you owe me a debt, and later I say, no, somebody says to me, you owe me a debt, and later I say to him, no, I don't, that could be regarded as retaliatory. Particularly if I say, no, I don't, and I'm going to issue proceedings challenging the existence of the debt. But I mean, the fact that something retaliates,
Yeah.
something else, does that take matters much further forward?
It depends on the facts of the case,
Yeah.
clearly. In some circumstances, it may not matter at all. In other circumstances, it could be relevant.
Mm-hmm.
And actually, this harkens back to a question that my Lord Smelly posed to me earlier. I think perhaps an observation that if you genuinely dispute something, when the petition debt is put to you, you would say, no, we don't owe this, and this is why we don't owe it. You would put your case forward. That wasn't done here. And there was this, as I say, a lacunae of any activity in Bermuda after the 2nd of August 2019.
Yes.
So when one looks at the timing, was this something that was going to happen anyway? Or anyway on this timing? Or is it a reaction to the petition? Because there is a tactic that can be deployed here, and indeed is being deployed here, which is to say the Hong Kong court is now seized with these matters. We have a convertible bond with a Hong Kong law governing clause and a non-exclusive jurisdiction clause. We have, as my learned friend said, repeating his submission, witnesses in China and Hong Kong. Isn't Hong Kong the better forum for it? That is a form of forum shifting, because the court is already seized in Bermuda with the winding up proceedings. Now, they are different in nature, of course, between a writ action and insolvency proceedings, but essentially trying to present an argument that the petition should be dismissed because shouldn't all this be dealt with in Hong Kong. My lord says there's authority both on that position, and I'll take you to that in a moment. It's a case that deals with a jurisdiction clause and its relevance to winding up proceedings. But in terms of whether it's retaliatory in nature, the judge was taken to the authority of rear company ex parte Finsoft, which was a decision of Mr. Justice Harmer, where the retaliatory nature of a action brought by the company is taken into account. Now, this is, my lords, if you can go to the respondent skeleton argument tab 2. And paragraph 22. There's a reference to two cases, so whether the dispute was raised late in the day and whether it is retaliatory in nature to the petition can be taken into account as a factor. There's a rear company ex parte Finsoft. And there's a quote from Harman J there that the later raising of the allegation. In fact, let's go to it in bundle edge. It's tab 17. 17, 170. If we start on page 368, look at the headnote. It said on the 18th of February 1991, Finsoft Holdings, the petitioner presented a petition to wind up the company. The petition alleged that the company had dishonored a promissory note the £5 million presented for payment on the 7th of January 1991. The company applied to have the petition struck out as an abusive process of the court, alleging that the promissory note had been obtained by means of fraudulent misrepresentations. Those allegations were first raised by the company in a writ action against the petitioner commenced on the 15th of February 1991. So in that case, the writ action was brought 3 days before the presentation of the petition. And it was held if there was a substantial dispute as to the debt upon which the petition was founded, the petition would be struck out as an abusive process of the court. It was irrelevant whether the debt was disputed in good faith. On the facts, the disputes raised by the company were not substantial. The late stage at which the allegations of fraudulent misrepresentations had been raised, and the evidence that the company was probably insolvent, suggested that the company was looking for any defence to avoid payment of the promissory note. Accordingly, the petition would not be struck out. And if we go into the body of that judgment,
So wait a minute, the petition, the promissory note was presented for payment on the 7th of January, and the allegations of fraudulent misrepresentation were made on the 15th of February. So that's within 5 weeks of the promissory note. Doesn't seem
yes,
too long.
the facts of this case. In our case, of course, there's a period between the 19th of September to the 21st of October. And then the body of the judgment at H380.
But I mean, say they were raised at a late stage, when it's 5 weeks, seems a little.
Well, there's further insight, I think, at page H380.
Right.
If we start just below A, it says, it follows I'm wholly unsatisfied. The disputes raised here are substantial. They seem to me to be fanciful, bearing in mind that these serious allegations of fraud were never raised until service of the statement of claim. They were never raised in a letter before action. They were never mentioned in the discussion between Mr. Peretti and others, including an English solicitor acting for the petitioner, which led to the clear answer on the 12th of February, only very shortly before service of the statement of claim, when allegations were made which were then rebutted and are now dropped. The late raising of the allegation seems to me to show they are the result of dredging about for any form of defence to avoid payment of this promissory. Now, this case doesn't establish any legal principle. That's not how it was used or cited to the judge. I mean, my learned friends on it is, you really can't consider this type of thing when looking at the bona fides of a dispute. But of course you can, because you look at all the facts. And it is a marked feature of this case that the allegations that were put forward, presumably pleaded during September, formulated during September and October, for the writ to be filed on the 20th of October, they haven't been raised with the petitioner. And if one goes back to that 2nd of August 2019 letter, it says in that letter that the financial department of Titan had looked at these contracts in May 2018. We know from Mr. Zhang, I don't have the reference to hand, but I can find it, that in Mr. Zhang's affirmation, he said the issue of these commodity contracts in April 2017 were part of the Special Investigation Committee. Now, that had been formed in February 2018 to look at another matter, the purchase of Opco, nothing to do with these proceedings. But certainly there had been plenty of time in which the company could have set out this dispute. And the notable feature of the 2nd of August letter is it doesn't say there's a conspiracy. It doesn't say that Sino, or others are controlled by Tangle Weeping. It doesn't say that there's been any flow of funds out of Titan. It doesn't allege improper purpose. The only point that really survives into the evidence that the company introduced on petition was a rather feeble point. And that's to say, well, Mr. Chan Lu is the nominee director, nominee shareholder of a BVI company. Is a man of relatively modest means. And there's no dispute, he was employed by a corporate service provider, it seems. There is no raising of this form of dispute, and that is something the judge is entitled to take into consideration. The first it's heard in Bermuda is after it's been set out in a writ in Hong Kong. There is a second point. It's actually a different point, but since we're on this authority. This Justice Harman also considered the relevance of insolvency. So just below at C, I believe I'm entitled to bear in mind that it appears on the evidence that this company is very likely insolvent. I accept Mr. Cyber's submission that insolvency is not an issue. What is an issue here is whether the creditor is a true creditor, in the sense of having a debt not disputed upon substantial grounds. Nonetheless, an actual insolvency would give the likely motivation for those controlling the company to raise any form of defect that can be grabbed out and dressed up in some way to avoid payment. And that seems to me exactly what has happened in this case. So again, if you're looking at all the facts of the case, the appellant agrees the judge was right to do. How can you exclude a factor such as insolvency? Because as the judge said, it's going to be something that would potentially colour the views taken of the company's position. There is a further authority which is found at tab 4 of the bundle. This is Dennis Rye and Bolsover District Council, Court of Appeal decision, or Justice Mummery and Elias. This involved a company was indebted, this is H3, to the local district council for council tax in respect of several properties. The company didn't comply with liability orders made against it from the Magistrates Court. The council issued a statutory demand in the sum of just under £17,000, which was unpaid, and then presented a winding up petition based on the statutory demand. The company disputed the debt, stated it was in a position to pay its debts, including the amount claimed on the winding up petition, and asserted a cross-claim that would exceed the balance of the amount claimed by the council. It submitted that the petition should be dismissed and the council should pay the company's costs in resisting it. The judge rejected the company's contention that it had a genuine and serious cross-claim against the council, as the evidence of the cross-claim was insufficient to establish such. He disregarded it and found that about £5,000 was due from the company to the council. If we go into the body of the judgment, it's H34, paragraph 18.
I'm just reading on it. After the money was paid, the judge then made an order for substitutional supporting creditors, gave permission to amend the petition and directed reimbursement. What was the amendment?
Yes, so immediately after the company's ruling, yes.
I haven't yet seen that this was the case where there was, where he said that there was insolvency. Never mind, maybe it will come from.
My lord, this is not insolvency. I was going to take paragraph 18. This is about late raising of a.
That's why I wondered what the substituted petition would.
Well, my lord, I suppose this is interesting to the discussion we had a short while ago about the possible options, because in this circumstance, the company's case didn't reach the threshold. They then paid up the judgment debt.
Right.
And of course, under the winding up, another creditor can apply to substitute.
Yes.
And the petition continues.
Paragraph 18.
Paragraph 18. So, Mr. Joseph's main criticism of the judge's decision was that it placed too much weight on the company's failure to bring proceedings for repayment or to take steps to challenge the liability orders on which the council based its statutory demand. Although Mr. Joseph had to accept the factor that factor was relevant to the assessment of the genuine and serious character of the company's cross-claim. There was, he insisted, no legal requirement that the company should take proceedings to enforce its cross-claim in order to raise it as a defence to a petition to wind up. And then under 19, this is halfway down, a company is not prevented from raising a cross-claim and winding up proceedings, simply because it could have raised or litigated the claim before the presentation of the petition, or it is delayed in bringing proceedings on the cross-claim. The failure to litigate the cross-claim is not necessarily fatal to a genuine, serious cross-claim, defeating a winding up petition. However, in deciding whether it is satisfied that the cross-claim is genuine and serious, the court is entitled to take into account all the relevant circumstances, such as the fact that the company has not even attempted to litigate the cross-claim, or that there are any reasons why it has not done so. So, another form of disputed debt, this time on a cross-claim basis. And the company is only raising it after the petition has been presented. Now, in those circumstances, again, the judge is entitled, as he did, to take into account that factor. Now, it's not prescribing a legal duty on the company. It's not saying the company is obliged to bring forth its counterclaim, I suppose it's a separate claim, as soon as possible. But it is a factor that goes to qualified a substantial dispute. My lords, on the insolvency point, since we're dealing with that at this stage as well, there is a further authority. It's re-record tennis sentence. It's tab 33. And this is a decision of Mr. Justice Hoffman, as he then was. And if we go to bundle page 8565, and if you look down the right-hand side of the page to G, it said by Mr. Justice Hoffman, the fact that the company against whom the petition is presented is hopelessly insolvent is not, of course, a ground for allowing the petition to go forward if there is a bona fide dispute. But the fact that such insolvency must have been in the minds of the company's officers during the relevant period does tend to colour the question of whether the dispute is bona fide. And he's summarising, he says, in my judgment, as an answer to the petitioning creditor's claim, the dispute over the cables, the patch, and the weed has been conjured up with the company in an attempt to stave off liquidation. As it is now admittedly insolvent, it seems to me the proper course is to allow the petition to go ahead, and the motion will therefore be dismissed. And what the judge is saying in G is, if you are proceeding, for instance, on the basis of a statutory demand, that is your ground of petition. If you want to argue actual insolvency, an application could be made to amend. But the mere fact that the company is insolvent doesn't mean an order should be made in a statutory demand case. That's nonsensical. But it does tend to colour the question whether the dispute is bona fide. Because, of course, if a company can pay the debt, but nonetheless, the robust term says, we don't owe this, there is a dispute, that is going to carry.
So the passage relied upon by the Chief Justice.
Yeah. Re-record tennis centres and rear company ex parte FinSoft were authorities cited to the judge below. So these are factors the court can take into account. And when my learned friend says, well, you can't take insolvency into account, he's conflating different things, because he'd be entitled to argue. Well, you can't argue insolvency. You can't ask the judge to make a finding of actual insolvency and wind up the company on that basis, unless you amend your petition, because you have not pleaded that ground. And he's conflating that requirement with what the judge can take into account when considering the question on the facts of whether there is a bona fide dispute on substantial grounds.
Yes,
When he can take into account the facts.
what you say seems on the authorities to be right. It's actually curious. If you claim actual insolvency, you must prove actual insolvency. But in a disputed debt case, you can take into account the fact that there's strong evidence to show that the company is insolvent, because that may be informed one as to the validity of the dispute. Although for that purpose, you don't have to show that the company is actually insolvent. Degree of mental gymnastics is involved.
Yes, I suppose it's this. I mean, the judge decides the petition as it's presented to him. So it's on the basis of deemed insolvency.
Yeah.
It needs to be, my learned friend would say, an amendment to argue actual insolvency.
Yeah, it does. You do it.
My learned friend mentions in his skeleton argument a case called GFN in Cayman, which considered whether the court had any residual jurisdiction to wind up without this kind of amendment. And the decision, I think it was Mr. Justice Voss, was against.
President Chadwick.
I'm brave. There seems there's no residual jurisdiction of the court simply to wind up. It must be responsive to the petition being put to the court. Now, that can be dealt with by amendment. My point here, though, is the short point, that of course the judge was entitled to take into account potential insolvency. He was entitled to take into account the retaliatory nature of the Hong Kong proceedings, and they are perfectly permissible findings in the circumstance.
Which was the Cayman case on residual jurisdiction not existing?
GFN Corporation. GFN.
GFN. It's in the head, isn't it? Where is it?
Yeah, it's
It's with it. There's it. Thank you. Yes.
My lords, the next ground of appeal relates to the Hong Kong action, which takes a central position in the appellant's skeleton argument. Now, this relates back to ground 2.1.5 of the notice of appeal. And when this was first put, it wasn't entirely clear what was meant. And it seemed to be suggested by that ground that the judge gave insufficient weight to the Hong Kong proceeding. Now, my lord, in terms of grounds of appeal dealing with weight, it's not sufficient, as you know, simply to argue, well, greater weight should have been placed on a particular factor or argument, unless the appellant can demonstrate the weight placed on that issue by the judge was irrational. The phrase perverse is used in some of the cases. My lords, if I doubt I need authority for that, but just for your reference, within the respondent's skeleton argument, and this is at paragraph rather than take the paragraph, I'll take the authority. It's a decision of the Privy Council. It's Ming Shui Hung versus JF Ming. It's in the authorities bundle at
15, is it?
My lord, yes, you're ahead of me. And judgment of Lord Briggs, it's paragraph page 8341, the bundle. Roman numeral 3. In fact, it's worth reading the beginning of 28, the other page. In the board's view, these criticisms of the judge's reasoning in his exercise of discretion do not withstand analysis, taking them in turn. Over the page, Roman numeral 3, a view that a judge should have given more weight to a relevant matter is not within the scope of the appellate review. Matters of weight when exercising the discretion of the judge, provided that his assessment of weight is not irrational. And my lords, it's slightly off subject, but there's another paragraph I intended to take you to earlier in my submission. You go to page 339. Paragraph 22. There's a paragraph that deals with appellate restraint. And it said at 22, the question whether a judge has failed to take something into account is not to be answered by an overzealous dissection of the language of the judgment. In Piglowska, Lord Hoffman said, an appellate court should resist the temptation to subvert the principle that they should not substitute their own discretion for that of the judge by a narrow textual analysis, which enables them to claim that he misdirected himself. Finally, it's not an answer to the need for the exercise of appellate restraint for the appeal court to regard itself as well placed as a judge to carry out the task. In Zuckerman on civil procedure, it's observed, it has been said that a review of the lower court's decision on the question of fact is different from a review of the lower court's exercise of discretion. The difference between the two kinds of judicial exercise is undeniable, but it does not call for a difference in appellate restraint to interference with the lower court's decision. While it is true that in the case of discretion, the appeal court may be as well placed as the trial court to exercise it, the primary responsibility rests with the trial court, not the appeal court. This is true not only with regard to case management decisions, but also other decisions requiring the balancing of different factors, as in care proceedings, for example. So, my lords, question of weight of the Hong Kong proceedings. Well, if it's argued that the judge didn't give careful consideration to the care proceedings, that is clearly wrong on the face of the judgment. And I've already taken you to the various parts of the ruling that deal with that Hong Kong judgment. For reference, they are paragraphs 58 and 59. So it can't be a question of weight. So what then is the relevance of the Hong Kong proceedings? And my lords, there is a further helpful authority. It's in Bundle H at tab 5, and it is the case of BST properties.
Is it really being said that it's anything more than the fact that Hong Kong is a proper forum, if indeed there is a bona fide dispute?
The judge took into account the Hong Kong proceedings as a relevant factor. That's why he gave them careful consideration in paragraphs 58 and 59. But what he was being asked to do is to dismiss the petition on the basis that Hong Kong was the more appropriate forum. And as part of this argument, the appellant was saying, well, look, there is a bona fide substantial dispute. These are matters that are better dealt with by cross-examination and by the application of rules on discovery and so forth. So that was the argument being put before the judge. Now, you can consider that both in terms of retaliatory bona fides, whether the Hong Kong writ is retaliatory or not. And he can consider it also in the exercise of his discretion. So is he going to make the order? Is he going to dismiss the petition? Is Is he going to adjourn or stay? And it would be rather, in ground 4 of their grounds of appeal, the appellant says, well, the judge failed to give sufficient weight to the possibility of an adjournment of the Hong Kong proceedings, Bermuda proceedings, whilst the matter is resolved in Hong Kong. Now, that's a rather perverse submission in the circumstances, for reasons I'll come to, from the company's behalf. But it's not thought out, because that ground seems to proceed on the hypothesis that the judge has concluded there is no bona fide dispute on substantial grounds. And bearing in mind the similarity of the allegations forming the defence in Bermuda and the claim in Hong Kong, it would be entirely nonsensical to decide to adjourn the Bermuda proceedings in those circumstances. But another part of
Again, it would be nonsensical to adjourn the Bermuda proceedings because.
Well, yes, it's not thought out. So if you're proceeding on it seems ground 4 does proceed on hypothesis. The judge was right to conclude there wasn't a bona fide defence.
Yeah, I see. Yes.
So having reached that conclusion, bearing in mind the similarity
Yes,
of the allegation, it's just been
yes,
reversed.
on that hypothesis. Yes.
Where does the Hong Kong action fit in? So if we look at
What
BS,
is the judge? There's a lot of curious phrase in the judge's judgment where he says that he's not satisfied there's a real substantial offence. But then says, of course, that the liquidator to decide what he does thereafter, which may include adopting proceedings elsewhere. What is he contemplating?
I think just really a statement, almost a statement of fact of the situation, because the judge is considering this threshold test for substantial dispute. He has determined that it hasn't been met.
Yeah.
But the effect of making the winding up order and appointing provisional liquidators, there's no automatic strikeout, as it were, of those Hong Kong proceedings. They, of course, are in a different jurisdiction. They continue to rumble on. But now there is a change in control of the company. The board of the company has been removed.
Yeah.
The JPLs take charge of the company. It's a matter, it's just a natural consequence. It would be a matter for the JPLs to take a view on those.
Perhaps the manner in which the JPLs chose to deal with proof of debt and whether that was acceptable to the.
Yes, I mean, it's the debt of the petitioner still has to undergo the proof of debt procedure. I read it very much as the judge is stating the simple fact that the petitioner would still have to submit a proof of debt. As my learned friend says, there is a right of review against any decision by the provisional liquidator within the Bermuda court. And
So the petitioner could say has to produce proof of debt, and it theoretically be open to the liquidator to say, well, I've read with interest the Chief Justice's judgment, but I'm persuaded in the light of matters that have been drawn to my attention that there is a defence to this. Would it?
well, I think they would inevitably have to take a view on the Hong Kong proceedings.
Well,
They would have to see.
forget about the Hong Kong proceedings. The petitioner has to produce proof of debt. That means he has to prove the debt. That means if there's an issue, the debt doesn't arise because there's a set-off which extinguishes it. That is something that has to be addressed. Is it theoretically, by which I mean actually but unlikely, open to the liquidator to say, despite what the Chief Justice has said, I am persuaded by what I have heard that there is a defence that needs to be investigated, and therefore I will investigate.
I had not taken anything the Chief Justice had said would prevent the JPLs from fulfilling their normal duty.
Yeah.
And that would be part and parcel of looking at all debts
Yeah.
to which proofs are submitted.
Yes.
And they would, of course, have to take their own view
Yeah.
as to the Hong Kong proceeding.
Yeah.
Now, of course, the petitioner would hope that the view that the JPLs took would be that there's absolutely nothing in those Hong Kong proceedings against Sino. And Sino are only involved in those proceedings because of this very tenuous argument. They are somehow under Tang or Wei Bing's control. And the primary defendants in the Hong Kong proceedings, the main targets of it, seem to be Tang and Wei Bing. And there seems to be this broader conflict between Tang and Wei Bing. And Mr. Zhang is the sole executive director of the company as it stands, or as it stood prior to the order. My lords, we were at much heralded BSD Properties Limited. And if I can take you, the relevance of this case is that there's a winding up petition brought, and there is in terms of the
I'm sorry,
debt document.
which case is this?
This is BST, it's tab 5. It's a decision of the Court of Appeal. If we go into it's Lord Justice Jonathan Parker, and there was an argument put. The argument is in paragraph 25. And Mr. Reynolds says he relied on clause 18 of the loan contract, which I'd read earlier, which formed the basis of the grant of permission to appeal. He asserts there are proceedings on foot in Hungary, albeit proceedings to which the company is not a party. And over the page on 31, it said, secondly and more important, whether or not proceedings raising a dispute as to the effect of the loan agreement could be stayed on the basis of clause 18.
31.
Paragraph 31. So whether or not proceedings raising a dispute as to the effect of the loan agreement could be stayed on the basis of clause 18, which is a jurisdiction clause. That does not, in my judgment, affect the question which was facing the company's court, namely whether the petition debt is bona fide disputed on substantial grounds. And it's worth looking briefly just at that. Clause 18, it's set out in paragraph 50. And the quote from clause 18 is, the party shall attempt to settle disputes occurring in connection with this contract amicably. In the case their attempt is unsuccessful, they stipulate the exclusive competence of the Metropolitan Court of the Republic of Hungary. So the debt document has an exclusive jurisdiction for the courts of Hungary. And an argument was being placed, well, isn't the Court of Hungary going to be the more appropriate jurisdiction? And as Lord Justice Jonathan Parker concludes, it doesn't have that effect, because the question posed to the company's court, as posed to the Chief Justice below in this case, is whether the petition debt is bona fide disputed on substantial grounds. It is not an answer to the petition claim to say that these matters should be dealt with in Hong Kong, because my learned friend puts it very, he puts it very highly in his skeleton argument. And in terms of the Hong Kong action, he argues that because of the Hong Kong proceedings, specifically because leave has been given by the master in Hong Kong to serve out of the jurisdiction, that the Chief Justice was precluded, that's the word he uses in his skeleton, precluded from determining the threshold test of bona fide dispute on substantial grounds. And that is quite wrong. If I need authority for that, that is BST. And it's also rather odd how the argument is being put at all, because it's being suggested. And I think it's worth looking, indeed, at the appellant's skeleton argument on this point back in bundle G, tab A.
Sorry, where?
So the appellant's skeleton argument is page G8.
Oh.
Paragraph 20. My learned friend says, on hearing of the petition, Titan argued the proper course was to allow the issues, which are the subject of the dispute, to be resolved in the Hong Kong action through the normal litigation process, with the benefit of discovery and a full trial involving the cross-examination of witnesses, and that the petition should be dismissed or stayed, generally pending a final judgment in the Hong Kong action. And then if we go on to paragraph 40, under a heading, the proper approach, it said that Titan's primary submission was and remains as inappropriate in the context of a winding up petition for the court to engage in a detailed review of the merits of a dispute in order to make an assessment of its merits. As here, the dispute involves serious allegations of dishonesty and it's subject of ongoing litigation, which is being actively defended by the petitioner and is at the pre-discovery stage. Pausing there, of course, it's not at the pre-discovery stage because the company's evidence in July 2021 was that Mr. Tang and Dr. Wei Bing had not yet been served. But we have no idea whether they've been served today. But moving on to 41, confronted with proceedings.
I'm sorry, isn't that a fortiori means that it's at the pre-discovery stage?
I'd taken it to read they'd just about to reach the pre-discovery stage. But my lord, I think your interpretation, in fact, may be the better one. I'm grateful. 41, say, confronted with proceedings for which leave to serve out had been granted by the Hong Kong court. It said, in respect of which Sino Charm had not availed itself of procedures in Hong Kong to bring an abusive claim to a summary completion. And then he says, whether the veracity of the dispute had been affirmed by a professional appointed by the Hong Kong court, that this precluded any independent investigation of its merits by the judge, where the investigation would necessarily, without discovery or cross-examination, be based on incomplete evidence. And this is where we must pause and look at the chronology of the proceedings again. So, filed in September 2019, the Hong Kong writ follows on the 20th of October 2019. No application for leave for service out is made until the 17th of August 2020. The order is not made until the 28th of August 2020. And I'm taking these dates from the company's evidence from Mr. Liu Kit Win. And then the proceedings themselves aren't served on Sino Charm until the 14th of October 2020. So about a year after the pleadings were filed. Now, my learned friend says, well, this is maybe difficulties of cable, etc. Again, that's a submission without evidential basis. Mr. Zhang, for his part, in his evidence, explains the delay as being due to the need to provide full and frank disclosure in the Hong Kong proceedings. It's an unusual point to make, but that's the one he relies upon. But if one considers the chronology of the proceedings, there was supposed to be a substantive hearing, 21st of February 2020. That was then adjourned to be heard around about April 2020. And then that's got interfered with by COVID. It's now suggested by the appellant that because there wasn't an application to set aside service, which could only have been brought after the 14th of October 2020, they would have needed time to take advice and prepare evidence from that. So really November, December 2020. The fact that a different judge, a different court, in different jurisdiction, applying a different test for leave to serve out on an ex parte basis has granted such leave, in some way operates either as a concession by Sino Charm or requires them as an obligation to open a second front by beginning either strike out or set aside proceedings in Hong Kong. Is in my submission risible? What was happening in October of 2020 was the petitioner was trying to get the petition relisted. And it was the company's conduct at that point in refusing to provide availability. They were trying to get leading counsel to appear at the hearing that delayed the listing of those proceedings. And there was court difficulties at the beginning of 2021. But my learned friend relies upon 6 factors in his submissions. This goes back to, it's paragraph 22, A to F, page G9. There are 6 factors that he says the judge failed to take into account. The fallacy of this argument is, had the matter been heard as it should have been done on the 21st of February 2020, these factors wouldn't have existed. They only arose through the passage of time because proceedings in Bermuda got delayed and were finally served in Hong Kong in October 2020. It suggested that the second front should have been open. There's no obligation to do that. It doesn't amount to a concession. In fact, it's of no relevance whatsoever to the Bermuda proceeding. And it was also put forward without evidence of litigation in Hong Kong. And it's implied that striking out is a quick and summary procedure. But of course, that may not be the case, depending on which jurisdiction you're in. It's not the case often in Bermuda. We hear complaints, it's not the case in England. I suspect it's probably the case in Hong Kong, but I don't know. My learned friend doesn't know. He doesn't advance the point on evidence.
So what exactly is it you don't know?
My lord, I'm addressing what I would say is the fallacy, the 8 factors, A to F, on page.
I follow that, but what exactly was it you said you didn't know?
My lord, I don't know how promptly the Hong Kong courts will be able to deal with the strikeout application. I suspect it might be many months, it could be a year, it could be more. I don't know my learned friend.
There's very much judgment.
No evidence to lay before the judge on that point.
Yeah.
Indeed, one might also assume that the test for strikeout in Hong Kong is the same. You're looking at plain and obvious cases, you're only looking at pleadings and you're assuming the statement of claim is correct. It's an assumption. I don't know that. I'm not a Hong Kong lawyer. No evidence was led on that point. So this is really the appellant just taking advantage of the passage of time and partly its own delay of the proceeding. And the judge quite properly dealt with the Hong Kong proceedings for what they were, which is just part of the factual matrix. It didn't obviate, didn't detract from his duty to consider the threshold test of bona fide substantial dispute. And that's what he proceeded to do. My laws, there is therefore no, in my submission, no merit whatsoever in that particular ground of appeal. When the argument on the 6 points applies equally, whether it was to be heard in April, these factors only arose later. My lord, I was going to move on to a further ground of appeal. I note the time, which is coming up to just past 4:22. I don't know if this would be a good time to break.
Well, let's just see. How much longer do you think you have?
I would hazard an hour to finish my submission.
Right. And the council sitting behind you, I can only just see you from here.
My lord, we think we'll be about an hour.
Right.
Right. But we could be less than that. We could be half an hour, 45 minutes.
Right.
But we estimate that just in case.
And Mr. Potts, how long do you think?
I mean, in light of your lordship's questions during argument, I imagine my reply can be pretty short, but perhaps an hour.
And when do you kick off tomorrow?
Well, with apologies again, I'm scheduled to appear in court in Cayman between 10 o'clock Cayman time and 1 o'clock, which is between 11 o'clock here and 2 o'clock. So in a sense, if I could be released between about 10:45 and 2:15, that would be helpful to me in that other court.
It might be easier if we actually left the morning free for the criminal case and started in the afternoon. Is that possible?
Can be, yes.
You need to check.
Yeah.
We will rise to make some inquiries.
That's what you have. Yeah. So I just think it's we'll take all of the, you know, some sort that's right. Exactly. Yes. Yeah, I think of it. I look at you. Yes.
That's the same position. Reason.
Right. Well, we think that the most convenient course for all concerned is that we should start 2:15 tomorrow. If Mr. Potts is slightly delayed, we will forgive him. If he's long delayed, we will not.
Long delay will start.
If we're long delayed, we'll start without him. That's right. So that's, I think, best for all concerned. What I'm about to indicate some matters about which we may need assistance, but you should not assume from the fact that I ask the questions that they are premised on any view that we might have as the outcome of this case, because at present we don't have any. I went through a moment ago the possible permutations of result that might be reached in this case. One of the permutations was that we allowed the appeal, but upon the basis that the company was insolvent, allowed an amendment of the petition and made a winding up order in consequence. Under that heading, we would need to know, A, whether an application would in fact be made to amend the petition, and B, any of the potential mechanics involved, that is to say, whether it would be necessary to have an advertisement of the amended petition, and whether, if it's prima facie necessary, that can be waived or dispensed with, and any other complications that may arise. And we would also wish to hear from Mr. Potts and his submissions as to why we should not adopt that course anyway, assuming that those would be submissions.
Yes, well, I mean, by coincidence, we were just discussing between ourselves outside of court, but I would like to make submissions to your lordships as to why, certainly in light of the GFN decision, there's not actually, it's not an available course to the court, because the petitioner who has a disputed debt claim lacks all standing to present and pursue a petition if the debt is disputed. And so it's not theoretically possible we would want to submit based on that GFN case.
Well, we look forward to hearing those submissions. That may be the answer. I'll come back tomorrow to try and develop the point, but I just want to flag it up there because we'll answer the other issues on the alternative scenario as well.
Yes, of course. Well, that may be the short answer, but we need to know the answer, or at least the right route to the answer.
Thank you. Well, unless I can assist any further right now.
Not today. 2:15 tomorrow.